Hello.
Number 21.
Right.
5045.
Hello.
Number 23. 178.
Both being correct.
Right.
Yeah.
Lord, in regard to yesterday's matter, I have furnished that short note.
Yesterday's matter.
Yes, I just furnished it. Only thing your lordship put me a question, 10% enhancement on the consortium and all that, from which date? That is, my lord, I have written in the note, that is from the date of judgment passed in Pranay Shetty's case in 2017. Now that I have put it there in the second.
Not from the date of accident.
No. Your lordship will find in that Pranay Shetty's judgment, the last para, that is on the second page, your lordship will find. I have highlighted that.
Is it mentioned in that judgment?
That judgment, para 59.8, your lordship will find.
59 point. Okay, I will
Yes.
take.
All right. Much obliged.
For listing of two IS civil laws. One is for condemnation and another for
Code number 8. Senior court.
it is also of the other side I mention item number 19 yellow.
190.
19. It is not a senior counsel Mr. B. Datta is appearing.
Pardon?
Senior counsel Mr. B. Datta is appearing. Due to some personal difficulties unable to appear before this court. Can it be on 8th of September yellow? Will be here present. Time for the respondent. I've taken the concern of the other side. J.
Okay. As agreed by Lord and advocates of both the parties, with the matter after
On 8th of September, your Honor. 9th of September. Deeply obliged. Your Honor.
May I please, your lordship, I beg to mention item number 2 for adjournment, lordship. This matter may come up after 2 weeks.
Miss, your good name,
K.L. Aryanpan.
learned counsel for the learned
Appellant.
counsel appearing on. No, okay, your name is there. Learned counsel for the applicant. With you inform the other side.
Other side too. Actually, I'm appearing on behalf of SC Biswas. There's some personal difficulties. So
No, that's all right. You have to obtain consent from the other side. Did you inform the other side? No.
no, lordship.
Then wait, we will call the matter.
My lord, I would like to mention item number 13, my lord. This will be adjourned, my lord.
What day?
There is a talk of compromise between the parties, my lord. And I could not contact the other side, my lord. I could not contact the other side, but there is
Okay.
talk of compromise.
You could not contact.
I am the appellant.
No, you could not contact the other side.
Other side could not.
Then what to do?
But this is
We'll
talk
call the matter. Wait for some time.
13 number item.
Because if we grant adjournment to you, then the other side will come later on and will complain.
May I please? Your Lord? But
Yes.
may I mention a IA for orders on Tuesday, my lord?
Which matter?
Well, IA in RFA, my lord, for Tuesday, mentioned for listing.
Code number 8.
My lord, yesterday his lordship passed the order as not by, my lord.
Okay.
That is.
What do you want?
On Wednesday, my lord? Deeply.
May I please, Lordship. Lordship, in item number 6, Lordship, I have filed
Item
an
number?
affidavit. 6, Lordship. I have filed an affidavit in opposition yesterday, Lordship. First, that is not in record. Record may be called for, Lord.
Okay.
May I please, your lordship, I beg to mention item number 11. Lordship, we have applied for certified copy, and as the documents are voluminous, so it would take some more time to obtain those copies, certified copy.
You are appearing for
The petitioner,
your good name
MSN Chaudhary.
and so learned counsel. You inform the other side.
Lordship, they are informed.
Informed.
Yes, your lordship.
Lordship,
Tribune Bora.
Lordship, we are from the other side.
So then from the other side, will come discuss the matter after? When?
Lordship, after 3 weeks.
After there,
May it please your lordship.
Lordship.
Lordship, in regard to item number 6, we have filed our affidavit in reply yesterday in connection to criminal civil revision, my lord. Reports may be called for. The respondent number 5 has also filed their affidavit in opposition.
already,
Oblige, your lordship.
Yeah, please, your lordship. For item number 12, lordship, I'm praying for adjournment on behalf of the appellants, lordship. Due to some personal difficulty, my lord, this matter may be listed in the next week, my lord.
your name, please.
Why Borvia appearing on behalf of Mr. H. Gupta, lordship.
Mr. Sudro, Garden Council, appearing on behalf of State Council for the appellant. Press for listing the matter after,
A week, lordship. After a week.
after there.
Highly obliged.
May I speak, please, your lordship, conducting advocate is in traffic jam. Your Honor. Ask what about for time being.
Yes.
Thursday, there is a prayer for adjournment of the matter.
Lordship, but they were asked to take steps, I think,
Respondent number 1.
because he has expired. Lordship, as per the last order, he has expired on 2011.
But the conducting council is absent.
Lordship.
Is ALR Yantha.
Yes,
Learned
lordship.
council appearing on behalf of certain citizens. Learned
Lordship.
for the applicant.
May I please, your lordship? Lordship, as per my SCBSO's instruction, learned counsel, he told me that 2 weeks time may be granted to file a substitution petition for legal errors.
Press for granting her time. Complete the legal errors of number 1. There is according to allow. Which appears for us.
Oblige.
One.
May I please order the second application. Earlier it was disposed of by directing the accused to approach the trial court. And they approached the trial court and
So what is it? The case is pending now.
My lord, case is now already, now evidence case, my lord, PW, yes.
How many witnesses have been examined?
Total 9 PWs, my lord, 2 already PW, 1 and 2 examined, my lord.
today's 345 days of detention of this. Number 1 and 333 of the accused number 2.
What is the ground for filing the second application?
My lord, kind of errors
Page number 42, my lord. They have approached the trial court, my lord. And on 29/01/2025, the prayer was rejected by the trial court, my lord. And
Page number,
page number 42, my lord. 42, last page. So here, my lord, search is filed, my lord. There is no need of any kind of investigation.
so that's why the quantity is commercial for how to satisfy the requirements of 37.
Yes, my lord.
37.
37. So one thing, my lord. Well, one thing. Page number 17, my lord. Page number 17, my lord. The arrest memo of the accused number 1. So there is no any witness. This is a violation of, my lord, section 48 of the BNSS. There is no any witness, my lord. Ground is here, my lord, but there is no any witness. There is no any, my lord, criminal antecedent. There is no any criminal history. Very young as, my lord. Page number 17, my lord. Arrest memo of the accused number 1. Another thing is there, my lord. There is 3 accused.
Where it is provided that the signature has to be obtained. The signature of the witnesses has to be obtained.
Signature of the witness is here, my lord. Signature of the witness is here.
Where?
Paragraph column 5, my lord. Arrest memo 17. Signature of the arrestee is here, but witness is not.
Where it is provided that signature of witnesses are to be taken.
Yes, my lord.
Where it is provided that the
My lord, section 48, my lord.
witnesses have to be taken.
Section 48, my lord. BNSS.
40.
Yeah, my lord. Section 48 says, my lord, obligation of person making arrest inform about the arrest to relative on or a friend, my lord. Every police officer or other person making any arrest under this Sanhita, BNSS, my lord.
Pardon?
BNSS, my lord. Section 48. Section 48.
Section
48, my lord.
but when the person was arrested,
Still on,
The accused number 1 was arrested on
24.
4/9/2024, my lord. As per arrest memo.
And my lord, one accused now, Rosidul Ali arrested on 14/9/20.
14/9. But a third accused, Robinson Ali, he's in London on bail, my lord, on 21/7/2025 by the Body High Court. Same case, my lord.
you were referring to section
48, my lord.
48.
48, my lord. Every police officer or other person making any arrest under this Sanhita cell for which gives the information regarding such arrest and place where the arrest person is being held to any of his relatives, friends, or such other person as may be disclosed or nominated by the arrested person for the purpose of giving such information, and also to the designated police officer in the district.
Where it is provided about form
Because my lord, the arrest memo of the accused number 2, my lord, in page number 80, my lord, there is a witness, my lord. Maybe her mother, my lord. In the arrest memo of the accused number 2, my lord, page number 18, there is witness. Page number 18. There is no need of further investigation, my lord. Circuit is complete. Investigation is complete, my lord.
How do you satisfy the requirement of this section 37(1) or not two?
My lord,
Section 37, subsection 1 or not two?
Well, otherwise, my lord, he has not taken, there is no, my lord, he has not taken any ground, my lord, good ground for granting of bail, and my lord, he has to satisfy regarding 37(1)(2), my lord. Those, my lord, contraventions are of commercial quantity. Only on the ground that search sheet file, my lord, and only investigation completed, that cannot be a ground for granting bail, my lord, in this case. First, he will have to satisfy. And regarding any of the grounds, my lord, regarding compliance of 4740, he has not taken any of the grounds, my lord, in his petition.
Have you gone through the record?
Records, yes, I have gone through, my lord. I have only,
Whether the grounds of arrest were communicated?
my lord, regarding as because he has not taken any of those grounds, so my lord, I have not, my lord, gone through those provisions for them, my lord. He has not.
Then we have to make it.
Then, my lord, I will point out, my lord.
We will go to the record and pass out.
Okay.
But
my lord,
there is no submission on your part as to how you satisfy the requirement of section 37.
yes. There's no any ground, my lord. I admit, my lord.
Could you go ahead,
Yes.
Mark?
Hello.
On the last date, the records was all for PCR. They have not yet come. The office note dated 11/8/25.
May I please your lordship? There was one IA which is still pending. I have filed one stay vacating petition, your lordship.
Last time also he said that, then lordship said that it will be finally heard on receipt of the PCR. And already the order is there in the IA lordship that it should be listed before by another, another bench lordship, that it should be listed before the appropriate court. And last time, lordship, your lordship said that let it be heard finally. That is what. And PCR from Guwahati itself. Yes, lordship, from Guwahati. I do not understand why from Kamrup they are not sending. It is. I'm ready to do the hearing. MSCT 2.
Number 5 and 6.
1 to 4.
1. Updated 11, 8, that record has been today, but that is such urgent reminder the verdict for transfer ordered is the matter after 2 weeks.
Highly obliged.
Obliged, your lordship.
May it please your lordship. Here in this case, on IA is pending for disposal 2739. IA has been filed for renovation of the rice mill situated in the scheduled land also.
Lordship, here in this case, you're supposed to file our objection. Objection is ready, lordship. Today I am filing, lordship. Today, lordship.
They have
Even
taken
next
time
week-
from 3/1/2024. Okay, lordship. Yes, they are filing the objection.
Next week, lordship.
Hard sir, learned product. So hard sir,
T. H. Chaudhary.
T is learned. Is objection is relative and we filing during the course of the day. And as for the signal letter, after 1 week,
September 1st week, lordship.
Lordship, date on last of August, lordship. Date may fix, lordship.
I will be out of session. That's why I am thinking on past. I will.
Obliged, lordship.
Other day, the Okalatnama was not showing.
My lord, I file Okalatnama on behalf of respondent, my lord. So I need some time. I will file affidavit in opposition.
or the part started for the and third
As that.
is the started the subset. After 1 week.
Or 2 weeks, your honor.
Yes.
My lord, no, he may take time as he likes, my lord. He has to file a reply. But then the issue is, my lord, on section 9 only. The court inherently does not even have jurisdiction because as per the Guardians and Ward Act, it has to be instituted, my lord, at the place where the child is residing. And child is residing at Hailakandi. So the court with jurisdiction is actually Hailakandi, and I'm seeking a transfer to Hailakandi, therefore, from Silchar to Hailakandi. So that is the limited issue then.
Okay.
My lord.
After 2 weeks,
My lord.
then it's ordered for self-public.
Obliged.
Deeply obliged.
But anyway, Passover timing, the affidavit has not come. Okay. This revision petition is filed by the auction purchaser. And the borrower approached the DRT tribunal, my lord, without making us party and challenging our auction purchase, sale notice. Thereafter, they make them a party, but regarding the land documents and other documents, they wanted to file some more documents, which was not in their possession. That has been refused by the learned tribunal. What they have placed at page 16, my lord, that against the impugned order I have done. Relevant paragraph at page 16. Is the as remove difficulties before selling on the property. So option, the bank is bound to remove such obstruction that they have not done. The petitioner respondent number 5 is a third party and a stranger to the mortgage deed. Therefore, he has no locus to challenge the validity of mortgage deed. The petitioner is not seeking to assert any ownership to respect number so and so, as he cannot make any comment or obstruction with regard to so and so ownership and possession of the surface applicant in respect of that number so and so of the land resource. So, my lord, without making us party, they have challenged my tender notice and my purchase, my lord. I have deposited in 2019 September 6 crore 11 lakhs. That money is lying, bank is not able to hand over the property. In the meantime, my lord, they have obtained some kind of, my lord, status quo order. The borrower has obtained status quo order. Therefore, my lord, also an obstruction has come. The bank is not taking any initiative to give me the possession. Instead, for last 7 years, they are sitting and fighting the case in between borrower and my lord bank. And I am not party to that, because borrower, I have nothing to do with the borrower, nothing to do with the bank. Of course, bank interest lies. They should have, my lord, has taken the money in 2019 September, my lord. They should have given my possession, because my money has got some value. But they are not doing that. They are instead, my lord, supporting the borrower and making an unforeseen excess, whereby, my lord, I have suffered for last 7 years. And now, my lord, where I have filed an application to place some documents regarding the land, then also, my lord, so that was refused. The document, my lord, list of documents is at page, my lord. My application, it reflects, my lord, that page 19 of my application. The application I have filed before the Learned Tribunal. Here, my lord, 1 has already been given. 2 I wanted to submit. 3, my lord, 8 piece of documents. 3, then, my lord, 7, then 11, 13, 15, 16, 17, 18. For the interest of justice and for better perusal of the case, my lord, these documents are relevant. So, if your lordship kindly allow me, Supreme Court also, my lord, in numbers of cases, the interest of justice, if somebody wants to file some documents, that can be a place that can be allowed before passing the judgment. Now, my lord, the judgment is yet to come. Hearing is going on. So, my lord, if the documents are at least the learned court below, learned tribunal, they can go through the documents, and, my lord, after going through the document, the learned tribunal can assess my position about that. Otherwise, I am simply auction purchaser, but because of that tussle, I'm not getting the possession of the land. This is the simple issue. I have nothing more than that. And I have come to know that the borrower has to pay 12 crore loan, and thereafter their bank and, my lord, whatever they are doing. But the auction, my lord, has taken place. Sale deed has been issued in my favor. For last 7 years, they are sitting tight and not making any arrangement to give me the possession of the land. And the affidavit the bank has filed, they have also filed. I filed a reply also. That is also very unfortunate. Borrower is right and left scolding me in the affidavit, this, that, but I have nothing to do with the borrower, because it is between the relation is between the bank and the borrower. So, borrower, although it's submitting so many things, my lord, that I am not concerned, and I'm not be affected unless, my lord, bank is giving my possession of the land. Because the sale has become absolute in 2000, my lord, 19 September. After issuing the sale notice has been issued. So, my lord, it's a very simple case, and I don't think so, my lord, they should have any objection, either borrower or the, my lord, bank, because certain documents only I want to place, and for the better perusal of the case, and I'm losing on, my lord, benefit of 6 crore 11 lakhs.
Whether those documents were related
Related to some land, actually, my lord, what happened? The land mortgage was given to me. But, my lord, the borrower is now showing that that is not the land we have given on mortgage. I am actually mortgage different plot, adjacent plot or whatever it is, which is not accessible. It is a bank has to settle. We need not have to come to the court, my lord. Bank should have settled. Bank should have, my lord, given us the position. What mortgage they have taken, we have nothing to comment on that. But bank is not taking the right side. That's why upon auction, and I have purchased, I have got sale notice also, and I have deposited all the money in 2019 September. So 7 years has almost passed, my lord. They have nothing, they have not coming forward, they have not given any relief. And, my lord, in that case, it has become complicated. And regarding loan and other things, it is between the borrower and the bank. I have nothing to comment on that. So my case is very simple, and, my lord, I have some of the Supreme Court cases directly in my page. Page 9, my lord. I have cited some of the judgments. Paragraph 14, that the petitioner respond number 5 begs to state that there are several notable Supreme Court cases, laws related to filing of additional documents after written statement.
Page 9 of your
Page 9, my lord,
of
of the application, revision petition. That means that they are really there. Really there, court of there. That I'm submitting the judgment, my lord. The Kalyan Singh, that was submitted 1990. The Supreme Court held that the court has the power to allow the filing of additional documents at any stage of the proceedings, even after the written statement has been filed. Next, my lord, the Rameshwar Lal versus Jagadish Singh, 2005-10 SCC, page 49. I'm placing the judgment. The Supreme Court observed that the power to allow the filing of additional documents is discretionary and should be exercised judiciously. Next, my lord, Srimati Sneha versus Jagdish Sal, AR so and so. The Supreme Court held that the court can allow the filing of additional documents even after the arguments have commenced, if it is necessary for the just decision of the case. Next, the State of Maharashtra versus Hindustan Construction Company Limited, or SCC, the Supreme Court observed that the power to allow the filing of additional documents should be exercised in accordance with the principles of natural justice. Next, Messrs. ICDS Limited so and so, Hyderabad so and so, the Supreme Court held that the court has the power to allow the filing of the additional documents even in appeal proceeding. So my right is seriously infringed, and they are fighting between them, and I have been suffered at the worst. Because my money is stuck, neither I'm getting the land nor I'm getting the money. So this is my simple case, my lord. Your lordship may kindly allow these 8 documents to place before the even already I have placed.
My lord, I'm appearing for 1 and 2, my lord. Now, yes, if your lordship would kindly come to the order by which notice was issued in this case, my lord, on 35/25.
page number.
No, my lord, order in this particular case, my lord.
Okay.
Order sheet.
Yes, ma'am.
Please come to para 5 of that order, my lord.
Yeah.
The petitioner herein has assailed the order dated 8/1/25, passed in IA number so and so, by the learned presiding officer, Debt Recovery Tribunal, Guwahati, whereby various documents which the petitioner wanted to bring on record was not permitted. This court shall pass appropriate order after service is completed upon the respondent number 1, 2, and 3, who are applicants in the proceedings under section 17 under Service Act. Now this is important. This court further observes that pendency of the instant proceeding shall not bar the learned Debt Recovery Tribunal to proceed with adjudication of the essay number so and so. So this honorable court never considered it fit to pass any interim order. On the contrary, my lord, permitted the Debt Recovery Tribunal to proceed with the essay. Now, my lord, the final hearing has been concluded and essay is now reserved for order. Huh? Yes. Now, my lord, let us come to the, my lord, my learned friend has placed few judgments by the Honorable Supreme Court regarding permissibility of adducing additional documents. There is no dispute, there is no doubt. But it all depends what is the relevancy of those 8 documents. Why that 8 documents have not been placed in this petition? Even in the earlier revision petition also, those 8 documents were never placed before this Honorable Court. Now, my lord, kindly see, end of the day, why the application was rejected. The initial IA which was rejected was IA number 724 of 24. That was rejected merely because, my lord, they could not establish the relevancy of those additional documents.
That is not the correct thing.
Now, my lord, kindly see.
I did not enclose the objection.
Madam says it.
Only for that.
Now, my lord, my first point is, as has been observed by the learned DRT, the additional documents which are sought to be introduced is not placed on this before this honorable court. Neither it was placed before the tribunal. Now there is no explanation whatsoever how these additional documents which they want to introduce are relevant in the instant case. But it's not that filing of an application seeking to introduce additional documents will be allowed by the court merely because the application has been filed. It is so mechanical. So party must establish, be it plaintiff or defendant, my lord, they must establish. Yes. On the issue of amendment, Supreme Court has been very liberal. It has been said, even after a judgment is reserved for, a case is reserved for judgment, amendment prayer can still be permitted. Why about other stages? So there's no dispute. But end of the day, my lord, those documents must bear some nexus with the object of introducing the document. If those objects are missing, why court will permit? Now the tribunal has precisely did not permit because the relevancy was not made out, my lord. Then, my lord, they have filed another IA 265 of 25, making more or less similar prayer. That fact has been suppressed. We have brought out in this our affidavit, my lord. IA number 265 of 25, 269, sorry, of 25 has been filed. Then, my lord, most importantly, a title suit is pending. That fact has also been suppressed. Title suit number 251 of 22 pending in the Court of Civil Judge number 1 at Guwahati, my lord. Yes, 251 of 22. And very most importantly, my lord, recently there is a report given by the, my lord, rather an order passed by the co-district commissioner which clinches the issue, my lord. They should assail that order before the Board of Revenue. Why they are coming here? Now please come to page 151, my lord, of the affidavit. This is very important, my lord. This was passed on 5th of March 25 after before that. Please come to page 151, my lord.
Yeah.
Now this is dated 5th of March 25. The case has been taken up for consideration. An application was submitted by Balwan Bhama on behalf of Vaishnu Devi Traders Private Limited for boundary determination of land under DAG number 802 of Patta number 78 in Kahikusi village, Dokhin Rani under Azara Revenue Circle, and for cancellation of mutation on the land under DAG number 756 of the 7 Patta. We are concerned with this, Miller. In this regard, a notice dated 30/11/24 was issued summoning the applicant and Sri Sanjeev Jaiswal, the director of Prism Alloys Private Limited, for a hearing at the undersigned's office on 12/12/24. The issuing officer duly dispatched the notice and submitted a report. On the scheduled date, both parties were present. Upon examining the documents submitted by the first party, Sri Balwan Brahma, it was found that applicant is not a recorded pattadar of DAG number 802 under Patta number 78 of Dakshin Rani Moja, Kahigusi village. Additionally, no valid document regarding purchase of the land were provided except for a sale letter obtained from the bank. Actually, this property was purchased in an auction conducted by the bank, Miller. The second party, Prism Alloys, represented by Uttam Malakar, submitted attendance and land-related documents. Upon verification, it was found that Sanjeev Jaiswal purchased 2 biga 4 kata and 16 lasses of land under DAG number 802 of Patta number 72/8 through a registered sale deed dated number 6/11 on 21/1/06. Additionally, 3 kata of land under DAG number 756, this is the land in question, were purchased to another registered sale deed number so and so. In the first party, Balwan Brahma reference a letter dated 23/8/24 sent by Assistant Survey Director to Azara Revenue Circle Officer recommending a review of the matter. Accordingly, a report was sought from the Azara Revenue Circle Office to notice dated so and so. The circle officer submitted the report on 11/12/24. According to this report, 3 kata of land under DAG number 756 exists to the south of the National Highway. However, the record did not provide any clarity on the disputed land under DAG number 802. Therefore, this is important. Therefore, the undersigned's office requested another report by letter dated 12/12/24. In response, the circle officer submitted report dated 4/3/25, which stated that disputed land under DAG number 802 comprises 3 bigas 6 lasas, while DAG number 756B contains 3 kotas. The total area of both the DAG is 3 bigas 3 kota and 6 lasa. The report also confirmed that land under DAG number 756 is located to the south of the National Highway and DAG number 80 lies further south of it. Furthermore, regarding Sri Balwan's claim that he purchased 2 biga 4 kota 16 latha under DAG number 802, the report clarifies that a portion of DAG number 756 exists between DAG number 802 and National Highway. Since the total, we are concerned with the existence of this 3 kota of land in between, Miller. That is the bone of contention. Since the total land area exceeds what the applicant claims, it can be conclusively stated that land claimed by Balwan Brahma does not entirely belong to him and his claimed land is not adjacent to the National Highway. Well, against this order, they have neither preferred anything. This order has attained finality till date. So what my learned friend is fighting for, Miller? So my humble submission is, Miller, this introduction of this additional document cannot be merely on the asking. The party must establish the relevancy, etc., etc. And kindly see how the petition has been filed. That a suit is pending, that has been suppressed, that another IA has been filed after the earlier IA was rejected, and this honorable court also, they could not succeed. Ultimately, they withdrew the earlier case, Miller. As prior to this, another IA, civil CRP was filed, Miller. That was withdrawn because the court was not inclined to interfere with it. Now, this is the second time they have come. Here also, they have not mentioned anything. So, my lord, this 3 kota land in between 802 exists towards the south of the land, and that is clarified, my lord. Now, unless those orders are set aside by either Board of Revenue or somebody, some other forum, my lord, where is on what basis the other side is laying its claim? And the essay is already, my lord, heard. Now, final order is awaited. In that view, the matter, my lord, I think this application is absolutely without any merit, my lord. It needs to be dealt with accordingly.
Yes, madam, what is your answer?
Yes. Regarding, we have filed appeal before the DC regarding that order, my lord. As a circular, page 32. After that, my lord, we have filed appeal before the circle officer. District attorney. First, I'll tell my lord regarding the earlier civil division, my lord, because the objection filed by the my lord, filed by the borrower, we did not enclose. Therefore, my lord, court was insisting why you have not closed. And my lord, in the recording also, your lordship can see what was the actual status of that case on that time. And therefore, I withdraw and file a press because some other documents also, my lord, not enclosed because it was not prepared by me. Therefore, only I have appeared, so I was in a awkward position. Therefore, I have liberty has been taken to file a fresh petition, and after taking liberty, I filed this petition because earlier before filing the petition, it was not vetted by me. So I was in an awkward position. Secondly, my lord, that regarding the dark mentioned by my learned friend, that is the relevant for this land or that land. It is adjacent to highway or far away or whatever. But that will be mainly decided by the bank authority. Because whatever shown by the bank in the auction, then I was the highest bidder and I taken whatever land was shown to me, and therefore why should I go for a direct conflict with the other officers? Because it's a bank responsibility, whatever they have shown, whatever against what, it's, yeah, they are selling banana, storing banana, they cannot give me apple. So like this, my lord, the land, whatever shown by the bank authority to me, that is the mortgage land. So according to the mortgage land, I have deposited as the highest bidder. So I've deposited the money. It is a bank, my lord, later on, because now only I have in this proceeding, my lord, earlier I was not there. So my lord, it's bank responsibility to give me possession, land ABCD. But for clarification of the learned code below, I feel it necessary, therefore I have filed an application that is on page 18, my lord. Application for placing on record compilation of documents which will prove the bona fide of the bona fide auction purchaser moved for and on behalf of respondent number 5. So I have got very limited, my lord, right, and limited responsibility regarding getting possession of the land. I have nothing to, my lord, complication between them. Whatever land mortgage in the bank, my lord, that has to be given me, the bank is should given me the possession. Here, my lord, I have stated the reason for that in the present matter, respondent 5 is the bona fide auction purchaser who has purchased the secured asset of the borrower, Mrs. Brahmatra Technologies, which was mortgaged by the borrower, towards which mortgage deed was also executed in favor of respondent number 1, Canara Bank. The respondent number 5 has also paid the bid amount as per auction notice dated so and so in lieu towards which the respondent number 1 has also confirmed the option in favor of respondent number 5 by way of issuing confirmation mail dated so and so, and thereafter executing sale certificate dated so and so, whereby confirming the sale of the secured asset in favor of the respondent 5. That after the issuance of the sale certificate of the secured asset in favor of the respondent 5, the borrower is creating a mischief by clandestinely producing a false and fabricated sale deed dated so and so, whereby portraying the same to be an interloper property which is allegedly hypothetically being in existence exactly on the same place where the secured asset is also located. Hence, whereby very cleverly creating a melodrama with the convenience of the government officials by way of which the borrower is trying, they are a big party, my lord, very powerful party also, which the borrower is trying to dispute the measurement topographically of the secured asset which has been bona fidely purchased by the auction purchaser as filed. That in order to bring light upon the fraud which is being played by the borrower before this honorable tribunal, and to bring end to justice, whereby which the truth of the forged and fabricated sale deed number so and so, by way of which the borrower is trying to mislead this honorable court, can brought before open court. It is necessary to bring onto records and below mentioned documents which shall reveal the truth that the mortgage property secured assets of the borrower has no interloper property either in the north direction or the south direction and other cell deed number so and so, dated so and so, which is being relied upon by the borrower is nothing but a same piece of documents which is false and fabricated and has no authenticity. Moreover, my lord, I have not filed any title suit. I have been impleaded myself in the debt recovery tribunal because the court has given status quo order, my lord, on the sale notice. Auction notice, they have given status quo order. So, my lord, my right is directly affected because I'm the auction processor. That's why I have to go and make myself party. Otherwise, I have nothing to file in suit, my lord, because dispute is not with me, my lord. Dispute is in the bank with me. So, my lord, I have not filed any title suit, and there is no occasion to mention about, no question of suppressing the fact because they have filed a title suit. What for what is, I don't know. And my position is very simple. My position is very clear that I have purchased, I got the sale notice, I deposited the money, and my lord, in between, my lord, some unhappy certain things have been developed. Therefore, I wanted to file some more documents so that my position will be clear regarding the land. That is not the other land, it is that land which was shown by the bank.
Okay.
These documents
We'll
confirm that
first order.
And one more document, my lord, that is page 32. Only one. Page 32, my lord. That, my lord, these documents confirm that dispute is post-auction and approves non-existence of DAG number 756.
Report of
The comprehensive report on the present status of the land covered by Oh, okay,
My
madam.
lord, my only submission is, my lord, the order at page 151, which I have read, that clearly reflects the correct position, my lord. We are not disputing that she is not the auction purchaser. She purchased, but she is claiming more land than what has been purchased. That is what is clearly evident from this order passed by the my lord at on 5/3/25 by the key co-district commission, Jalupari.
No, Mr. Soturi, that will be examined by the DRT.
Yes.
That issue is
No,
to
my
be
lord,
examined
no,
by the
no,
DRT.
my lord, how can DRT has no mechanism, my lord? End of the day, it has to be settled in a civil suit, my lord. End of the day, my lord, Lordship will kindly appreciate one thing. Now, her claim is that I have purchased this property from in auction purchase. We say, to the extent of land you have purchased is okay, but don't grab my part covered by DAG number 756. That is the bone of contention. Now, the at least revenue authority's report is very clear. Now, there is apparently a dispute. We are claiming 756 is in between there. They are saying no. So who will decide it? If DRT, neither this honorable court nor DRT can. It is issue. That's why, my lord, we have filed the title suit where you are seeking right title to title of right title and declaration.
No,
Under High
this
Court
thing
almost
is not right. We are only to see whether the documents she brought
Yes.
Yes, ma'am.
produced before the tribunal
Yes.
are relevant or not.
Yes.
That is the question.
Yes.
Yes.
We'll pass the order.
Yes.
Very limited prayer. Yes, ma'am.
Reserve the order.
Obliged.
You go.
For the respondent number 4. What is-
Bank, Canara Bank, appearing for Canara.
So for the land which is has been mortgaged, it is 802 only. Now, we have not gone to the DRT. It is the borrower who has gone there and obtained a status quo order. We filed our defense. So far the surface proceedings is concerned. Now the matter is fixed for the final hearing. And in fact, on the last date before the DRT, their counsel had appeared and argued the entire case in length on merit.
This was pending.
On merit, and even they filed their written argument also. Last
During
week.
pendency of this petition, my lord, that also he should mention.
It
During
is,
pendency of
it is they who had appeared before them, and it is reflected in the order that I have enclosed. My humble submission is that let the DRT decide the entire surface, because it has been going on for a long time. We are unable to, because we are also in a dire strait.
Their petition was earlier dismissed by the
Right,
DRT.
right.
Therefore, they are before this court.
And you see, it is after 2 months that they had come here. And appeal lies before the DRT against an order, any order passed by the DRT. It is under section 18 of the Service Act. Where if you're,
So that's why that provision is there, but
Yes,
they
sir.
have opted for invoking the jurisdiction of this court under Article 227.
Right. Right.
But they're very limited there. That's why, my lord, I'm not arguing at them. Obligement.
Lordship, in this case, justice service has been affected on respondent number 2. Respondent 4 has expired, Lordship, as per information from the investigator. And in respect of Lordship, respondent number 1 and 3, respondent number 1 was originally addressed of Lakhimpur, but he does not reside there as per investigator, he resides at Guwahati. So in respect of 1 and 4, we will have to take Lordship paper publication. Otherwise, no other option. We don't have their address.
Or sorry, is this with or the applicant? So first we have to conduct the delay.
Lordship, in this, Lordship, only Lordship 2098 is today, Lordship. 2098.
098.
Yes, Lord.
098 is for
staying operation of
Stay.
Pakijai case, Lord.
the problem is that the main case has yet to be admitted.
Yes, Lordship. Yes.
Unless it is admitted, why should we pass such an order?
Then Lordship, in delay petition, Lordship also,
First
that,
we have to conduct the delay.
yes, Lordship.
Then we have to register the
Yes.
appeal.
Yes.
Only in appeal we pass the or after registration of the
Yes, Lordship. Appeal is already registered, Lordship.
appeal is registered.
Yes, Lordship, 43.
The delay condone or not?
Delay condone regarding Lordship, our petition, that is Lordship 3772, Lordship. 377223. There was some delay, Lordship, in our filing the petition to rector, Lordship.
Okay, MSC appeal was dismissed for default.
Yes, Lordship. Our name was not known. That is the reason.
But, that has not yet been restored.
Yes, Lordship. Because
This
there was,
petition is pending.
yes, there was delay.
So, first we have to dispose of this delay condonation.
Yes, yes. In that,
In I for the night, like, this application file under 150, part by the proceeding of that. But it appears that the MSC appeal, the MSC appeal number 42 has already for default, and nothing yet no file. And under limited application, I think it's number pending for delay. Of 127 days, starting the interlocutor. In that view of the method, court has passed of the interlocutor. Referred for delay. It appears that the applicant has already directed, take step by order date 56. Thus the service was affected.
Affected lordship in respect of Asano two, affidavit to that effect is to be, yet to be filed lordship. Only yesterday I got that.
So here, it's up, I think, respect of the number two services already affected by custom. And,
Four expired lordship.
and availability file, within a short period. And so here, further subset, respondent number four, already suffered damage. So he's a legal representative or to be break record.
Lordship, he is driver of other vehicle, lordship. So he was driver of the other vehicle. Two vehicles were involved, lordship.
Whether he
His legal heir, only wife is there. Had it been owner of it, that would have been different, but driver, the real defense is not there.
so he struck of his name.
Yes, lordship. Yes.
So here further subset. The legal heirs of the number four are not equal to brother record. As he was the driver of the other vehicle.
Other vehicle.
Other vehicle. In respect of number one and three.
1 and 3.
So here subset in department effect service of notice upon the appropriate response by paper public by substituted with notice shall be published widely circulated like fixing the matter of public and therefore the matter shall be listed for on so here bring or the notice published in the newspaper by way of an affidavit. It's like
I've been requested by my learned friend or other side to keep it for a time being. He's in on lakes now. I've been requested by Mr. M. Khan to keep it for time being. He's on lakes in under.
May it please your lordship, my lord. The lordship was pleased to admit the second appeal, my lord. In the meantime, they have already filed the execution, my lord, on 28/7. That is why, my lord, the matter was mentioned before, my lord.
yes,
My just my objection may be recorded.
part data part yeah but order for 5 date with order 39 1 the date 5 not the burden that's for it possible that for title level number for the data the connected appeal has already been admitted by the party. And the meantime, the party hearing execution proceeding
Money execution number 39 of 2025.
money
Money no. Money, title execution. Title execution. Sorry.
What?
39 of 2025.
39 of the 5. And as such, there is the requirement of staying the operation of the judgment till disposal of the connected appeal. Sir, how many learned counsel for the opposite party? How about opposed the bill? Where I have heard the sub learned for both the parties. I have come to the court and appears that has operated after and the record has altered and as such, there is a requirement for operation of the order dated according to the sub five was stand state are one
All right.
Well, my objection may be that. Okay.
Your Lordship will see the order dated 9/6/25. Your Lordship has raised a question. Your Lordship will come to the paragraph 32. The judgment which I have produced, my lord, it is of 23. 23 Supreme Court SC 122. In the, may I read, my lord?
paragraph number
32, my lord. May I read, my lord? In the light of the above discussion, the answer is in negative to the first question before this court, meaning thereby there is no difference between a party to a suit as a witness and the witness simpliciter. The second issue in this appeal, in view of the provisions noted above, the production of the document for both a party to the suit and the witness, as the case may be, at the stage of cross-examination is permissible within the law. Because here is also the documents were produced at the time of cross-examination by the insurance company, that is exhibit A, B, C, where there is an endorsement of the claimant's father, the person who is injured, that yes, he has authorized his son this. That is order, my lord, the provision of order 7, rule 14(4), order 8, rule 2A, and order 13 of rule 1, rule 3 has been already discussed on this issue, whether the documents produced during the cross-examination is to be valid or not. Is be taken into the court's documents or not.
How this,
Pardon, my lord,
how this decision will help you?
I couldn't get it, my lord.
How this decision will help you?
Well, Lord, here the documents which they have produced at the cross examination, there's an endorsement that he has authorized his son. And that has been taken into the account by the court. It's become a court document. That is why it is marked as exhibit A, B, C.
No, yet statement of the injured person was recorded by police during investigation.
Yes, my investigator by the insurance company. The investigator of the insurance company, during the cross, they have exhibited their document, A, B, C, and where it is stated that he has authorized son. On the basis of which this court, MSCT court allowed the petition. Well, there is another judgment of our High Court, my lord. The similar situation where the High Court, after discussing this, has remanded back to take the authority. Your Lordship will see that. 1992 Supreme Court.
Is the related paragraph?
Related paragraph is, my lord, 3, 6, 5, 6, my lord. Because here is the case, my lord, where the endorsement was not there. So they raised the question. And later on, the court says, okay, you are going on technicality, you will remand back. But in this case, my lord, the insurance company exhibited their own document in the cross, and that is, court has accepted that as a statement that he has authorized this. In the petition also, it is stated, I on behalf of my father. So it is a completely a technical ground, man. If your Lordship wants that it can go back, then it can go back. Or if your Lordship says that the statement recorded by the court is deemed to be an evidence, then your Lordship will pass the judgment on that.
Yes, sir.
Lordship. Let me see that document itself, that exhibit A. I'll introduce the document, Lordship. It is that whenever there is some accident like this, case is reported, insurance company normally depute a person who is called an investigator. It's not a formal investigator, but they have some people in their panel. And they go and they see whether the person is dead, alive, those kind of. Lordship may see that exhibit A. What is here, Lordship?
Page number?
Exhibit A, Lordship.
It's the record of the trip.
Yes, Lordship. It will be there. Yeah, exhibit A mark for us.
Though they have exhibited, the documents are not produced before the court also. Because they are taken, I have saved the record. There is no exhibit A, B,
It
C.
isn't marked as exhibit A.
That
How
is the
can
people
how can it be taken out of by somebody? It
Let's
cannot be
see,
taken.
go through the record. Your Lordship. Court's record
In
itself
this
says.
case, it will have to be introduced again, Lordship. It is there.
Because your Lordship will see the documents that the court has annexed with the judgment. The documents they have exhibited with the court document and in the judgment. Last one is exhibit 21. There is no exhibit A and B. The list of documents exhibited by the claimant. Witness, opposite party nil. Only in the cross they have produced that document.
Documents are marked as
Yeah, because at the cross, during the cross, they have produced a document. Otherwise, they have not produced any document. That is there in the judgment itself. Opposite exhibit nil. At the time of filing the written statement, they have never exhibited any document. Only in the during the cross, they have exhibited ABC.
I'm getting a certified copy from the court.
That is the. Okay,
This is certified copy.
So why the documents are not produced before the court?
But this has come from the records of the court, certified copy.
But the lordship will see the judgment. What the learned judge is saying.
Cross and agreement, it should be there. They have got it in court. Court recorded right.
The Goswami, you part in the certified copy.
Yes, person. I have a copy. I'll introduce it. This is a
It's
certificate.
a copy to me, my lord. Because in the we issue, that's protect the judgment of my. It's no copy.
It may be a part of claimant's exhibit, lordship.
No, the exhibit documents is আপনার লগে
Yeah, but cross of police claimant.
না exhibit নাই emotive documents নাই
Yes, I'll have to give my copy.
it's not there in my exhibit.
Because I'll file an affidavit enclosing the certified copy that I have with me.
Particular copy. Then any other point?
No, my lord, this is the only issue that my learned friend has raised about the authority. So I have nothing to say about the amount. So I have to clarify that point, whether the documents which are produced at the time of cross examination can be the part of the court proceeding or not. I have given the judgment. And our High Court also says this is a very technical issue. If your court feels that there is it can remand back for a test, for which the insurance company will again have to bear the excess interest for so long. It is matter of 16. So I leave it to lordship's decision.
Part, third argument, third. Goswami, you part in the copy.
Yes, sir. Do I, I'll file an affidavit enclosing this. Or there's a copy.
Any
I'll give the copies, lordship. I'll make copies.
Hello. Oblige your lordship. Copy to video. Listen. Listen.
But the precise question, my lord, here involves whether a stranger or a third party to an agreement to sell in a suit for my lord, specific performance is a necessary party or a my lord, proper party. Now here the trial court has allowed my lord, the respondent number 1, who is not a party to the agreement, that has been challenged. Now the facts of the case are such, my lord. The present petitioner, as the my lord, plaintiff, has instituted title suit number 40 of 2008.
So in a agreement, only two parties are there.
My lord,
In an agreement, there is only two parties,
two parties,
buyer and seller.
buyer and seller. Whether a third party or a stranger can be my lord, included by way of a filing of an application under order my lord, 1 rule 10. But the matter has been well settled.
Where is the Intune order?
My lord, at page 42.
Dated?
My lord, it's 7/7/2010. Page 42. If I'm permitted to, my lord, state the facts in brief, my lord.
the court has recorded a finding that the petitioner is not a stranger.
Lord,
to the suit.
that has been, my lord, challenged, my lord. And in fact, my lord, the matter was already decided, my lord, by a order dated 4/11/2010. But, my lord, technically, my lord, it could not be pointed out that notice was not issued. So therefore, a review application was filed subsequently. So the matter has come up. Your Lordship, may kindly entire facts have been condensed in the order dated 4/11/2010 of this revision petition.
That has been, my lord, set aside, my lord.
Yes, that has been
In
set
the review, that has been set aside.
That has been set aside.
Your lordship
because
may
of
look
the-
into, my lord, my learned friend is relying on that. My lord, your lordship can
Then
look into
what's-
that. That has been set aside in the review petition, my review petition. Okay.
That is what I have said, my lord. My lord, there is nothing, my lord, wrong in, my lord, looking at, my lord.
No, I'm
And
not saying.
Then, my lord, you are objecting to that, my lord, the court.
No, no, I'm
it is
not
a-
objecting. I'm
Yes, but
I'm
that is-
saying that
I'm
that has been
saying
set
that
aside.
It is still in force.
I'm only making a point. Your lordship can look into it, my lord.
I have said, my lord, that this has been, my lord, on a review application, this has been set aside, but the entire fact has been, my lord, reduced in that particular order. Therefore, my lord, I am pointing to your lordship. This is the order of review. It is merely on the technical ground, my lord, that notices was not issued. The law has not been altered, my lord. What I want to point out till date, my lord. That is the law. What is, my lord, stands.
If that order is set aside, then what remains to be decided in this meeting?
My lord, it was by a review, my lord. It is not set aside. In fact, it was recalled. It was recalled. Now, this is the, my lord, review order.
The order of this.
Lord, of this court, my lord, the order passed by this, that particular order of 4/11/2007, that has been, my lord, signed. So, lordship, I have to, my lord, adjudicate the issues afresh, my lord.
In fact, my lord, it was recalled, my lord, because the order was passed without hearing me. So that order is not there, my lord. That order was passed without serving a notice to us, my lord. So no, that order has been, my lord, in the review petition. It has been recalled. So that order.
On merit, my lord, my submission is the same.
I
What has been recorded.
understood.
On merit also in this petition now, my lord, my submission is what is recorded therein, my lord. Now, lordship will kindly find, my lord, the agreement is at page 18.
Annexure A.
Annexure A, page 18.
So, okay, it is 12 o'clock. I will take break 5 minutes.
My lord.
Resume after 5 minutes.
Lordship, lordship. Lordship may find, my lord, here the parties, my lord. Soilan Kumar, so and so, my lord. These are all have been made defendant in my suit, including, my lord, one Eastern Tea Brokers, my lord, who was a confirming party to the agreement. Its name appeared, my lord, in serial page number 19. my lord, page 20. And whereas the vendor has agreed to sell and purchase, has agreed to purchase DT, that is Duliabanti estate, including all movable and immovable property pertaining to and comprised in DT, free from all encumbrances and charges at and for a total consideration of rupees 1 crore 98 lakhs so and so. And the garden, whatever is having the liabilities, these are also mentioned, my lord, at page 22 of the said agreement. Page 22, these are also the, my lord, liability what is mentioned. Now, after, my lord, exercise of the, my lord, this auditing, etc., price has been confirmed, but they having not come up for the execution of sale deed. I have filed this, my lord, the title suit number 40 of 2008 for execution of the sale deed, where, my lord, all the parties to the, my lord, agreement were made party. My lord. Now, the present defendant, respondent number 1, on the strength of a, my lord, document, which is also annexed, my lord, will find at page 31.
Page number 31.
Page number 31.
Annexure B.
Annexure B1. Page 30. Account in respect of our dealings, that is sale of made tea and advance received from Agrawal Tea Company of Jorhat from time to time, as on 31/3/2005, have been finally settled with them today at Jorhat, and the sum of rupees 1 crore 53 lakhs and odd has been found to be due to them. We shall pay said sum to them as soon as possible. Our tea estate shall not be disposed of before clearing their dues. This has been a undertaking, my lord, given by one of the, my lord, sharers, co-owners, this Solendra Kumar Saikia, who is the respondent number 2, on behalf of all. On the strength of this, my lord, this Agrawal Tea Company has also filed a suit, the title suit number 3 of 2006. And in that, my lord, they had also paid for, my lord, cancellation of our sale deed, where we have been made party, and their alternative payer therein for my lord, money decree, my lord. Now, my lord, so far as this suit is concerned, my lord, to be a party, my lord, in a my lord, under the Specific Relief Act section 19, my lord, subclause A to E, who would be the necessary parties or the proper parties has been mentioned therein. The Agrawal Tea Company, my lord, the present respondent doesn't qualify any of them. So therefore, my lord, the suit was proceeding. At that stage, they have filed a petition, my lord, number 1523 of 2009 at page 32. Their sole ground is that they have also filed a suit. They have also challenged the agreement. So therefore, if any decree is passed in this particular TS number 40 of 2008, they'll suffer. That is their, my lord, contention. Against this, my lord, we have filed our objection. Well, also will find, my lord, the objection at page 32, my lord. Page 32 is a objection. Here we have categorically said, paragraph 3, that the petitioner is a stranger third party to the subject matter of the suit, no way connected with therewith, and as such cannot be a party to the suit, which is an exclusive dispute between the plaintiff and the defendant. That the content of paragraph 1 of the petition of the petitioner are wholly true. It is submitted by the plaintiff objector lawfully. It is exclusive right and within the domain the plaintiff to implead defendants against him he seeks relief. A third party against whom no relief is sought and or involved in the dispute cannot intervene and demand that he will be impleaded in the suit. That the contents of the paragraph 2 of the petition are also not disputed, which are matters of record. It is submitted by the plaintiff objector that in the said suit filed by the petitioner, they also filed a petition seeking relief under Order 39, Rule 1 and 2, Civil Procedure Code, which was dismissed by this honorable court. And that is with regard to suit number 3 of 2006. Their injunction petition was dismissed. That the matter regarding in paragraph 3 of the petition are also matters of record. It is pertinent to say here herein that the plaintiff objector was impleaded in the said title suit number 3 of 2006, which is pending disposal before this honorable court. The objector was impleaded by the petitioner himself seeking relief against the petitioner objector also, and as such their legal right contest the suit filing the written statement. The plaintiff objector also thereby contested the injunction which was already decided by this honorable court. Similarly, in the petition under Order 38, Rule 5, filed by the petitioner, the plaintiff objector was not earlier impleaded, knowing fully well that the relief sought therein was against the statutory right of the plaintiff objector, and no such petition can be lawfully disposed of by the honorable court. In absence of the plaintiff objector, the learned court thereafter directed the plaintiff objector to be impleaded, but as the present suit is for specific performance of an existing agreement of sale in between the plaintiff objector and the defendant number 1 to 8, the petitioner, who is a third party not in any way involved in the matter of agreement of sale, they neither have a right to the said relief sought in the suit, nor the presence of the petitioner is required for passing of an effective decree in the suit. That the claim in the paragraph 4 of the petition are also not tenable as required to be considered in the present suit. One of the defendant owing some dues to a party and is committing to do or do not something which prima facie void, irrespective in law, will not inoperative in law, will not provide any legal right to be impleaded in the suit. Suit for specific performance as the petitioner not fall in any of the categories specified by the subsection A to E of section 19 of the Specific Relief Act 1963. That the submission of paragraph 5 and 6 of the petition are also not tenable in the present suit. In view of the facts that the present suit is a specific performance of a contract which is between the plaintiff and the defendant being the parties to the suit, said contract will be decided in between them. No claim whatsoever of a stranger third party who is not a party to the said contract can be impleaded independently impleaded in a suit. If such a claim of a third party is to be decided in a case of a specific performance, honorable court is convert the present suit to specific performance into a title suit to decide such a right, title or interest of a stranger third party. These are the objection, my lord, and in fact they have filed a petition under Order 38, Rule 5. My lord, that has been, my lord, disposed of with regard to title suit number 3 of 2006. That has been decided by Order 34, 2007. I have annexed at page 36. My lord, injunction has been dismissed saying that it is a money decree. Then this petition is also, my lord, this petition was also dismissed saying that it is a money decree, nothing to do with the, my lord, there cannot be any restraint order with respect to the agreement. These are all in connection with my lord, title suit number 3, my lord. May I read, my lord, this one? This missed case arises out of the petition number 87 of the 06 filed by the petitioner plaintiff under Order 39, Rule 1 and 2, reduced section 151 of the CPC, praying for restraining OP defendant number 1 to 7 from executing sale deed in respect of their Duliabam Tea Estate in favor of OP number 8, and for restraining OP number 9 from joining confirming party without payment of the petitioner due as promised by OP number 1 to 7 in the undertaking dated 16/4/2005. The petitioner, that is Agarwal Tea Company, is a partnership firm by its partner Pramod Kumar Jalan. He is a dealer in made tea and used advance money to OP number 1 to 7 for purchase of manufacturing tea of their Duliabam Tea Estate. For such dealing with the petitioner, OP number 1 to 7 owed a sum of rupees 1,53,44,801 on 31/3/2005, and it was confirmed on 16/4/2005 by an undertaking by OP number 1 for and on behalf of other OPs for Duliabam Tea Estate. By the said confirmation, the OP had promised that Duliabam TE
would not be disposed of before clearing the petitioner's due. It is further stated by letter dated 5/12/2005, the OP number 3 on behalf of the Duliaban Tea Estate requested the petitioner to let them know the latest dues so that the said amount can be included in the liability list of Duliaban Tea Estate, and accordingly petitioner intimated its dues. And thus, as on 30/11/2005, the total amount dues is rupees 1,68,79,281 of OP number 1 for and behalf of Duliaban Tea Estate, acknowledged the receipt of the said statement and confirming party. This amount does not include in the agreement. But on 6/12/2005, the OP number 1 to 7 executed agreement for sale with OP number 8, that is Amaravati Tea Company, and OP number 9 joined as confirming party. By the said agreement, OP number 1 to 7 agreed to sell their Duliaban Tea Estate in consideration of rupees 1,98,59,044, but no provision has been made for outstanding liabilities in favor of the petitioner. The petitioner alone is a creditor for rupees 1,68,79,281 as on 30/11/2005, adducing therewith further interest at the rate of 15% per annum. As such, total amount stood at rupees 1,70,00,000 and odd. According to the petitioner, the agreement executed by OP under threat, coercion, and was not executed voluntarily, and it was in violation of undertaking dated 16/4/2005 made by the OP. And if the said sale deed is executed before payment of the petitioner's due, petitioners will suffer loss. According to the petitioner, he has a prima facie case. Balance of convenience is in his favor, and he will suffer irreparable loss if without payment of its due, OP number 1 to 7 executed the sale deed, and his case would be infructuous if temporary injunction is not granted at this stage, hence this suit. OP number 36789 resisted the petition by filing separate written objection. The other parties to the agreement resisted the petition by filing separate written objection, and the case against the other OPs has been ordered to proceed ex parte. The contesting OPs challenged the petition on the ground that the petition is not maintainable, as main relief of the petitioner is money. There is no cause of action of filing this petition. According to them, OPs never took any money from the petitioner, and OP number 1 has no authority to give the balance confirmation dated 16/12/2005 on behalf of OP, as he is not the sole proprietor of Duliaban Tea Estate. They also denied the letter dated 5/12/2005 written by OP number 3, and OP number 3 has no authority to write the same. According to them, in spite of getting knowledge on 5/12/2005, the Duliaban Tea Estate was going to be sold, the petitioner never requested the OP number 2 to 7 not to sell the same. Hence, according to them, there is no necessity to inform the petitioner about this. It is stated that Duliaban Tea Estate not running as was expected for last so many years due to some inevitable reasons. Annual production of green leaf was reduced abruptly. As a result, the production of made tea also reduced, and various problems arises among management, labor, workers, staff, and statutory authority. According to them, the agreement for sale dated 16/12/2005 was executed by the OP number 1 to 7 voluntarily, and it was made only to salvage the herbage problem faced by OP number 1 to 7. The petitioner has no right to question this agreement, as his claim is monetary relief. According to them, agreement for sale dated 16/12/2005 is a genuine one based on necessary and existence, and the said agreement was entered between the parties for lawful purpose, and it was not executed to deprive the creditor. According to OPs, the relief sought for in this suit is a monetary one, and the petitioner has alternative efficacious remedy for realization of their dues, and to prevent monetary loss, no injunction can be granted under Section 38 and 41 of the Specific Relief Act 1963. It is stated that petitioner has no prima facie case, balance of convenience is not in favor of the petitioner, and if injunction is granted and prayed for, the OPs will suffer loss and damage. They prayed for rejection of the injunction petition and to vacate the status quo order, which was passed earlier. Neither party adduced any oral evidence. I heard learned advocate both sides on injunction petition, peruse the petition, written objection filed by the OPs, along with the main TS number 3 of 2006, also peruse the document filed by both parties. From all this, it revealed that the petitioner plaintiff is a partnership firm represented by its partnership Pramod Kumar Jalan. As a dealer in Med Tea, he has a business relation with OP number 1 to 7, the owner of the Duliaban Tea Estate, and for this he paid advance money to them, and rupees 1,53,00,000 and odd
as balance as on 31/3/2005 was due to the petitioner by OP number 127, and it was confirmed by OP number 1 by his confirmation letter dated 16/4/2005, which is filed by the petitioner. It is also revealed that as per letter dated 5/12/2005, the petitioner submitted their statement of total dues as on 30/11/2005, which was rupees 1,68 lakhs and odd, and OP number 1 acknowledged the receipt of the same. It also reveals that as per undertaking dated 16/4/2005, the OP number 1 promised that they will not dispose of Duliabam Tea Estate before clearing the dues of the petitioner. Thus, it appears that the OP number 1 in favor of OP number 2 and 7 confirmed their liability. From the record as well as from the argument of OPs, it revealed that as the production of made tea of Duliabam Tea Estate reduced and problem arises among the management, labor, worker and statutory authority, an agreement for sale was made on 16/12/2005 for selling of Duliabam Tea Estate between OP number 1 to 7 and OP number 8, of which OP number 9 is a confirming party. Without informing the petitioner, for which the petitioner filed this case along with DS praying for injunction, thus it appears that the petitioner has prima facie case. From the record, it also reveals that main title suit petitioner plaintiff prays for a decree for declaration that the agreement for sale dated 16/12/2005 is illegal, inoperative and void, and for cancellation of the same, and also for permanent injunction against the OPs from executing the sale deed. But after filing this case, petitioner plaintiff prayed for amendment of the plain, praying for alternatively a money decree for rupees 1,70 lakhs and odd, along with interest at the rate of 50% per annum, and accordingly amendment petition was allowed by the order dated 25/9/2006, and the petitioner plaintiff also filed amended plan. During the course of argument, the learned counsel for the OPs argued that as the relief sought for this suit is monetary one, and for which petitioner has efficacious remedy under existing provision for realization of their dues, injunction cannot be granted under Section 38 and 41 of Specific Relief Act. Section 38 of the Specific Relief Act deals with provision when perpetual injunction is granted, and Section 41 of the said Act deals with the provision when injunction is refused. As per provision of this section, injunction cannot be granted when equally efficacious relief can be obtained by any other usual mode of proceeding. The subject matter of the present case is money, and the petitioner also amended his plain praying alternatively a money decree on his alleged due. The claim of petitioner is a monetary claim. A monetary loss or claim for which there is a remedy in appropriate form of law cannot be termed as an irreparable loss, and as such monetary loss always compensation with money, and where monetary loss can be compensated in terms of money, injunction cannot be granted in that case. Thus, it appears that the balance of convenience is not in favor of the petitioner. The alleged pecuniary loss cannot be termed as irreparable loss. On the other hand, it appears that if the injunction is granted, the OP number 127 will suffer loss considering the above mentioned ground, prayer of temporary injunction is rejected. So, it is very clear, my lord, that they are neither a party to the agreement, and they are also not necessary suit to this present suit number TS number 40 of 2008. So far as TS number 3 is concerned, they are also, while praying for injunction, the court has said that ultimately your relief is for money decree. So therefore injunction cannot be granted, which will otherwise, because by the agreement, the possession, etc., everything has been given. Now they having filed this petition, the court has passed the order, my lord, page 42, the impugn order. My lordship may come to page 47, my lord. Page 47, my lord.
Yes.
My lord, second paragraph starts with, my lord, in para number 1 of the petition. In para number 1 of the petition, it has been averred that the plaintiff have filed this suit for specific performance of the agreement for sale dated 16/12/2005 in respect of Duliabam Tea Estate against the defendant number 1 to 8, and this petitioner has not been implicated in this suit. Further, averment in the para 2 of the petition that the petitioner has earlier filed TS number 3 of 6 in their court, praying for their inter alia for declaration, injunction, and cancellation of agreement for sale dated
so and the plaintiff of this suit was impleaded as defendant number 8 in the said suit. That what reiterated what has been stated, madam. It has also been averred in the para 3 of the petition that the plaintiff of the suit has been contesting the said suit by filing written statement. The plaintiff also contested in injunction matter Mizze case number 13 of 06. The plaintiff is also contesting the petition of the present petition under order 38 rule 5 of the CPC in the said suit by filing objection after getting itself impleaded in the said petition. Again, it has been pleaded in para 6 of the petition. The subject matter of TS number so and the present suit is agreement for sale dated 16/12/2005. From the above, it is apparent that the present petitioner could no way be termed as a stranger to the suit. In such circumstances of this petitioner is obviously a necessary party to the suit. Hence, subsection A to E of section 19 of the specifically has no bearing in the present circumstances. My lord, my objection in the objection petition, which I have filed, my lord, page 32, none of the ground has been taken into consideration. The Supreme Court, my lord, way back in 2005 itself, my lord, it has been clarified, my lord. Specific issue, my lord. My lord, my objection in the my lord, objection petition, firstly was that, my lord, the plaintiff is the dominus litis. He has a right to choose who would be the party and against whom he'll be claiming the relief. And he being not a party to the agreement, he is a stranger. He is not even a subsequent purchaser to have some interest in the subject matter. Only the documents basis of which he is claiming is that undertaking. That is a undertaking with regard to the money. So that will be done, my lord. But all this objection, whatever I have raised, that has not a single has been taken care of, my lord. In this respect, my lord, as submit this, my lord, the case of Kasturi versus I am Perumal and others, my lord. The paragraph 1, my lord.
You have referred one document based on which he filed the petition. What is that document?
My lord,
Can
you
you
find that B1 at page 31.
It's 30.
One of the respondent giving undertaking on behalf of the other, my lord, these sellers, my lord, intending sellers, that this much is due and I'll not be selling the tea garden, which the other, my lord, the my lord, sellers or party to the agreement in TS number has filed, my lord, their objection that this is a valid agreement so far as the agreement executed with the present petitioner. And this respondent number 1 doesn't have any right to give an undertaking on behalf of the other defendants. All these things are there, which I have just taken your lordship to the order, of the injunction order, that was passed by the court in the title suit number 3.
There is an undertaking that the tea estate shall not be disposed of before clearing their dues.
One of the defendant has given the undertaking on behalf of the others, which where the other defendants or the intending sellers have denied that there is no liability, and the undertaking given doesn't have the authority because he is not the sole person there. My lord, case is, my lord, this liability, had it been shown in the liability, could have been different. Even if it is not, this is absolutely, my lord, the outside the agreement. The whatever liability they have, these have been mentioned.
Okay. What is the ratio in this case?
Well, that is the ratio. Your lordship will find this AR 2005 Supreme Court 2813.
11 paragraph.
Here, specific question, my lordship will kindly see, the paragraph 1. The only question that needs to be decided in this case is whether in a suit for specific performance, a contract for sale of a property instituted by a purchaser against the vendor, the stranger or a third party to the contract claiming to have an independent title and possession over the contracted property is entitled to be added as a party defendant in the said suit. Now, lordship may come to paragraph 14.
What for?
The principle has been recited again in paragraph 12. Then
yeah,
I read paragraph 14 onwards. As discussed herein earlier, whether respondent number 1 and 4 to 11 were proper parties or not, the governing principle for deciding the question would be that the presence of respondent number 1 and 4 to 11 before the court would be necessary to enable it effectively and completely to adjudicate upon this settle all the questions involved in the suit. As noted herein earlier, in a suit for a specific performance of a contract for sale, the issue to be decided is the enforceability of the contract entered into between the appellant and the respondent number 2 and 3, and whether contract was executed by the appellant and the respondent number 2 and 3 for sale of the contracted property, whether the plaintiff were ready and willing to perform their part of the contract, and whether the appellant is entitled to a decree for specific performance of a contract for sale against the respondent number 2 and 3. It is an admitted position that the respondent number 1 and 4 to 11 did not seek their addition in the suit for strength of the contract in respect of which this suit for specific performance of contract for sale has been filed. Admittedly, they base their claim on independent title and possession of the contract property. It is therefore obvious, as noted herein earlier, that in the event the respondent number 1 and 4 to 11 are added or implemented in the suit, the scope of the suit for specific performance of the contract for sale shall be enlarged from the suit for specific performance to a suit for title and possession, which is not permissible in law. Here is the same case, my lord. Moment he is been coming, then he will hesitate with regard to that undertaking, and then again I have to file a counter that this is illegal, inoperative, and liable to be declared null and void this undertaking given by the one of the co-defendants. So the suit for specific performance would be converted into a suit for title. In the case of the Vijay Pratap and others, Sambhu Saran Sinha and others reported in so and so, this court had taken the same view which is being taken by us in the judgment as discussed above. This court in that decision clearly held that to decide the right, title, and interest in the suit property of the injured stranger of the contract is beyond the scope of the suit for specific performance of the contract, and the same cannot be turned into a regular title suit. Therefore, in our view, a third party or a stranger to the contract cannot be added so as to convert a suit of one character into a suit of different character. As discussed above, in the event any decree is passed against the respondent number 2 and 3 and in favor of the appellant for a specific performance of the contract for sale in respect of the contracted property, the decree that would be passed in the said suit obviously cannot bind respondent number 1 and 4 to 11. It may also be observed that in the event the appellant obtains a decree for a specific performance of the contracted property against the respondent number 2 and 3, then the court shall direct execution of the deed of sale in favor of the appellant in the event respondent number 2 and 3 refusing to execute the deed of sale and to obtain possession of the contracted property, he has to put the decree in execution. As noted herein earlier, since the respondent number 1 and 4 to 11 were not parties in the suit for a specific performance of a contract for sale of the contracted property, a decree passed in the such suit shall not bind them. In that case, the respondent number 1 and 4 to 11 would be at liberty either to obstruct execution in order to protect their possession by taking recourse to relevant provision of CPC if they are available to them, or to file an independent suit for declaration of title and possession against the appellant or respondent number 3. On the other hand, if the decree is passed in favor of the appellant and sale deed is executed, the stranger to the contract being the respondent number 1 and 4 to 11 have to be sued for taking possession if they are in possession of the decretal property. That apart from a plain reading of the expression used in sub-rule 2 of Order 1, Rule 10 of CPC, all the questions involved in the suit, it is abundantly clear
that the legislature clearly meant that the controversies raised as between the parties to the litigant must be gone into only. This is to say controversies with regard to the right which is set up and the relief claim on one side and the denied on the other, and not the controversy which may arise between the plaintiff appellant and the defendant inter se, or question between the parties to the suit and a third party. In our view, therefore, the court cannot allow adjudication of collateral matters so as to convert a suit for specific performance of contract for sale into a complicated suit for title between the plaintiff appellant on one hand and respondent number 2, 3 and respondent number 1 and 4 to 11 on the other. This addition, if allowed, would lead to complicated litigation by which the trial and decision of serious questions which are totally outside the scope of the suit would have to be gone into, as the decree of a suit for a specific performance of the contract for sale, if passed, cannot at all affect the right, title and interest of the respondent number 1 and 4 to 11 in respect of the contracted property, and in view of the detailed discussion made herein above, the respondent number 1 and 4 to 11 would not at all be necessary to be added in the instance suit for a specific performance of the contract for sale. It is difficult to conceive that while deciding the question as to who is in possession of the contracted property, it would not open to the court to decide the question of possession of third party or a stranger as first lease. This question has come up because their claim was that they are in position. Here in our case, they are not in position, admittedly, but by and the decree that may be passed in our suit also will not bind him. The paragraph 17, let's look. That apart, there is another principle which cannot be forgotten. The appellant who has filed the instant suit for a specific performance of contract for a sale is dominus litis and cannot be forced to add parties against whom he does not want to fight unless it is a compulsion of the rule of law, as already discussed above. For the reason aforesaid, we are therefore of the view that the respondent number 1 and 4 to 11 are neither necessary parties nor proper parties, and therefore they are not entitled to be added as party defendant in the pending suit for a specific performance of the contract for sale. Subsequently, several decisions have come up, but I'll just refer one of the decision of 2019. This law is still in force, including 2022.
2019.
AR 2019 Supreme Court. Right? 7. Here, during the subsistence of the suit, the property was sold to another person, so he wanted to be implemented in the as a party defendant in the suit. Now, let's come to paragraph 5.1. Facts is somewhat similar. Suit for specific performance was going on during dependency of the suit. This property was sold by the defendant to third party, and third party wanted to be implemented under order 1 rule 10.
Here also the earlier decision was taken out of.
Low term. So that's the law, as on today,
Still in force.
I'm relying this paragraph 5.1 and 5.2, they are also the same decision, relying on the custody case. Okay. And why I'm referring to there may be a question that may arise because both the suits are pending in the same court and trial being going separately. Now, it may happen, both they are somehow at a time be contradictory to each other, the decree that may be passed in either of the case. So therefore, in earlier, why I'm referring to the earlier order, the court has said, since both the suits are pending in the same suit, same court, so the trial will proceed analogously. That was the observation. But if he is added to a party here, let's will kindly see. My specific case is that this is the agreement. I have to pay you this much of money. I have paid. Now you have to execute this sale. You don't execute this.
Now his case is that he is entitled to certain amount of money, and for that one of the owner of the garden on behalf of the others given an undertaking confirming the liability that yes, this much of money we owe and will not sell. But that will render the agreement odioous, is null and void. That has nothing to do with that, my lord. But if he is implemented, then again, it will be the separate the cause of action and separate decision. The instead of specific performance of contract, it will be a suit for declaration of right title interest accruing from this agreement as well as that undertaking. All these things. So therefore, this judgment clearly says all these things have been 2005 was passed much prior to the order passed by the trial court. That was also not taken into consideration. Okay, that is my whole submission.
Mr. Arora.
Well, my learned friend has argued about the injunction order and all that. But my submission is that the injunction order, has nothing to do with it, my lord. The injunction order was passed on the merit of it, my lord, and in that case it says that since you have paid a degree, alternative degree of money, my lord. So if you ultimately get a degree, then your proposal will be served, and for that injunction cannot be granted. Now, my lord, the trial court, my lord, here, my lord, your lordship will kindly consider that the two suits are pending. One is a suit filed by them, so far specific performance of contract is concerned. True, my lord, that I am not there a party. But my lord will kindly consider another aspect of the matter, that the suit, title suit number 3 of 2006, which has been filed by the, my lord, the respondent number 1, my lord, Mr. Agarwal Tea Company. My lord, there we have, my lord, paid for a degree for, my lord, declaring that agreement to be null and void. And in alternatively, we have prayed that, my lord, a degree, my lord, money degree may be granted in alternative. Now, that suit is pending. That suit, they have filed their written statement. The other defendants have filed their written statement. The matter is pending. That matter is proceeding before the Dibrugarh court, my lord. Now, my right, my lord will kindly see that why the trial court has made a, my lord, finding on the basis of the matters which has been placed, that I am not a stranger. If your lordship will kindly, the lordship has already taken note of, my lord, but it's still then, my lord, page 48. Their basic objection was that I am a stranger, so I cannot be made a party. Then section 19 of the specific relief A to E, my lord, I can, well, in view of that, my lord, I am not a necessary party to the, my lord, suit filed by them. Now, my lord, page 48, I am not reading the facts, my lord, earlier. The lordship has taken note of, from the above it is apparent that present petitioners could no way be termed as a stranger to the suit. This finding is very important. And, my lord, my submission that this finding on the basis of the materials on record is, my lord, is a correct finding, and, my lord, no error apparent or a gross error has been committed by the, my lord, learned trial court in passing.
If we take this finding in the light of the decision of Supreme Court in the case of this Kasturi,
my lord,
can it be said that?
My lord, yes, my lord, that decision has been, my lord, distinguished in subsequent decisions. And, my lord, in Kasturi, paragraph 13 is very important. My lord, I'll come to that, my lord. Let me complete the fact, my lord, I'll definitely come. In the subsequent two decisions, after the Kasturi, my lord, that has been distinguished. In the subsequent decision, it has been said that Kasturi was on a specific fact where the respondent number 1 and respondent number 4 to 11, they were claiming in that suit, my lord, I am saying, in that case, they were claiming possession and title, my lord. In subsequent case, it said that it is not the case. My lord, it cannot be said in any manner, my lord, that I have no interest. I have no interest at all in this property. Because your lordship will kindly see that if this property is sold to him, and my lord, ultimately it found that 1 crore 65 or 1 crore 53 lakhs or whatever it may be on that day was liable to be payable to me, my lord. Where from this money can be, my lord, recovered? And, my lord, while making this agreement, my liability, whatever liability.
Realize that amount, the other remedies are available, you avail it.
My lord,
No, to realize that amount, other remedies are available, you avail it.
no, I am availing, my lord. Your lordship, kindly see the property is sold, nothing is
But
there.
admittedly, you are not a party to the
That's true, my lord. I am not a party to that.
Yes.
That, my lord, I'm not
Yes,
disputing, my lord.
that no relief is being claimed against you.
Against me, my lord.
Yes.
But, my lord, my submission is that, my lord, it is not that, my lord, I am a stranger. I have some interest in the entire matter, my lord. And that finding, that's what the finding of the learned trial court is, my lord, that I am not a stranger to this. And in view of that, section 19A to E are not applicable in my case. Now, my lord, we continue at 2:30.
Another 10 minutes.
10 minutes. Lord, I'm showing this decision, my lord. But this Kasturi, if your lordship kindly take Kasturi also, my lord. Come. Hey, Kasturi, yeah. Baba, hey, come. No, okay. My lord, I'm coming first to Kasturi, my lord. My lord, that has already been cited. I'll come to my decision later on. My lord, in Kasturi, from para 1 to 13, the principles for making a party as a necessary party or proper party has been dealt with. Now, if your lordship will kindly come to paragraph 13. From the para 13. From the aforesaid discussion, it is illustrated that necessary parties are those persons in whose absence no degree can be passed by the court, or that there must be a right to some relief against some party in respect of the controversy imposed in the proceeding, and proper parties are those whose presence before the court will be necessary in order to enable the court effectually and completely to execute upon the sale, settle all the questions involved in the suit, although no relief in the suit was claimed against such person. Your lordship will kindly see this is very important. In the their suit, my lord, no relief has been claimed against it. But my right that, my lord, that an amount of 1 crore 53 crore was, my lord, liable to be paid. And they undertook that, my lord, they will not sell the property till the payment is made.
The undertaking was given by only one
My lord, that's true, my lord, maybe, my lord, but your lordship will kindly see, my lord, that will be decided on merit, my lord, in the case. Whether everything will be decided, my lord. In their case also, my lord, the plea has been taken.
Whether in a suit under a specific performance act that can be adjudicated by the court.
Lord, I am simply saying that I should be made party, my lord. The adjudication, whatever they file, they
Whether that undertaking is correct or is it given by that person or by other person also, whether that can be adjudicated in the suit under
Lord,
the
I can file a written statement to that effect.
Pardon?
I can file to written statement to that effect, and, my lord, I can cross-examine, my lord. That right will be.
Whether that contract can be no, a specific performance under the specific performance.
Because, my lord, your lordship will kindly see, my lord, it's not my lord, it is not a, my lord, specific performance of contract simpliciter, my lord. Where two parties are there, one is selling, one is, my lord, purchasing. Here the question is, my lord, that another party is also involved. And another suit is pending. Now, my lord, let us suppose that a decree has been passed in his suit. My suit will be, my lord, my suit, the prayer is, my lord, that this particular, my lord, the agreement for sale is null and void. So all the questions to be decided, that's what I have shown para 13 of the, my lord, 2005-6 SSC decision.
What in paragraph 13 it is.
Para 13, my lord, I have read it, my lord, again I am reading it, my lord.
No, that is paragraph number 12, what you have read now.
Oh, my lord, 12 in AI, my lord, probably. That is.
Yeah.
That is the paragraph.
Yeah.
My lord, I am reading from, my lord, the SSC, so that there is a difference, my lord. Paragraph maybe 12, my lord, in the AI. And subsequent decision, my lord will find, my lord, I have given, my lord, 2007-10 SEC.
What is stated in this decision?
Yes, my lord. Second flag, my lord. Second flag. My lord, there are 3 decisions, my lord, I am citing. The second decision I am reading because my lord is asking me, lord, that has been distinguished in the subsequent decision in 2007-10 SEC, page 82.
11 paragraph.
Paragraph 8 to, my lord, 8 to 14. Every party, may I read, my lord. Every party in a case has a right to file a written statement, decision in accordance with natural justice. The Civil Procedure Code is really the rules of natural justice which are set out in great and elaborate detail. Its purpose is to enable both parties to get a hearing. The appellants in the present case have already been made parties in the suit, but it would be strange if they are not allowed to take a defense. In our opinion, Order 22, Rule 42 cannot be construed in the manner suggested by the learned counsel for the respondent. Learned counsel for the respondent relied on a 3-judge decision in court of Kasturi. Case submitted that in case it has been held that suit for a specific performance of contract for sale of property, a stranger or third party to the contract cannot be added as defendant in the suit. In our opinion, the apostate decision is clearly distinguishable. In our opinion, the apostate decision can only be understood to mean that third party cannot be implicated in a suit for a specific performance. He has no semblance of title in the property in dispute. Obviously, a busybody or interpolar. This sentence, this is very important. A busybody or interpolar with no semblance of title cannot be implicated in a suit. That would unnecessarily protect and obstruct the proceeding of the suit. However, the apostate decision will have no application where a third party shows some semblance of title or interest in the property in dispute. Even in, my lord, the 2005 case, my lord, in para 12, that fact has been taken note of. Now, para 14.
Sir Agarwal, the
Yes.
question is whether a two-judge bench decision can
My lord?
overrule the decision of a three-judge bench.
Not overruled. Well, it has been interpreted, distinguished and because your lordship will kindly see on the fact, it says, I am reading para 4, my lord. My lord, para 14 is important for that purpose. That decision has not been overruled, my lord. It has been distinguished in para 14. In view of the apostate decision, we are of the opinion Kasturi is clearly distinguishable. In our opinion, it cannot be laid down as an absolute proposition. My lord, this is important. That whenever a suit for a specific offence is filed by A against B, a third party C can never be implicated in the suit. In our opinion, if C can show a fair semblance of title or interest, he can certainly file an application for implement to take a contrary view would lead to multiplicity of proceeding because then C will have to wait until a degree is passed against B. Then C filed a suit for cancellation of the degree on the ground that A had no title in the
But
property
in the
dispute.
present case, you have already filed another title.
No, that's why I'm saying, my lord, that my lord, what prejudice will be caused to him, my lord, if I am made a party to it. I have already filed a suit, my lord. I have made them party. They are contesting the matter, my lord.
So already there is a multiplicity of proceedings.
My lord.
Already there is multiplicity of proceedings.
But proceeding is already filed, my lord. My suit is prior to them, my lord. I have not filed this suit. I filed this suit in 2006 itself.
2006.
My suit was prior to their suit, my lord. They filed in 2008. Prior to filing of their suit, I filed, my lord. And my lord, the defendants who sold the property, they have also taken a counterclaim that the agreement which has been filed, my lord, they are seeking for a specific performance, is, my lord, null and void. That is a counterclaim that is in the present suit, that is also there. My lord, it is not that, my lord. Your lordship will kindly see that, let us assume that, my lord, I am trying to, my lord, be, my lord, persuading my right so far 1 crore something is concerned. My lord, had been a case that that agreement was made and they are ready and willing to do it, my lord. They could have done, they could have, my lord, made the sale deed till now, my lord. So, my lord, it's not that, my lord. What they are trying to, my lord, give a picture. My lord will kindly see in agreement, they have not disclosed this, my lord, yet. I'll come to that agreement also. My learned friend has read in page 22. They have given the, my lord, these are the money. Liability. So you pay 1 crore 8 lakhs rupees, my lord, they will sell it out the property. My lord, I'm not arguing. Though it has been taken note of, my lord, multiplicity, my lord, I have filed my suit earlier, my lord. This suit came later. My lord, had it been a case that, my lord, I am a busybody or interposer, my lord, I have nothing to do with this. My lord, I may not have anything to, my lord, argue before my lord. But, my lord, your lordship will kindly see, my lord, the matter has not been decided on merit as yet by the trial courts. Whether the only one person has a right to, my lord, give an undertaking or not, whether that money is payable to me or not, my lord, those will be decided in the suit, my lord. At this stage, my lord, before my lord, is whether I have to be made party or not. Even if I made party, my lord, no prejudice will be caused to them. And it is not that I have no interest at all. My lord, the money was given for, my lord, labor payment and other things of this, my lord, tea garden. The money was lent for payment of labor and other things, my lord, for that purpose it was given. It was not that it was simply, my lord, given money to them for some other purpose and all that, it was paid for that purpose. And, my lord, subsequent in 2010 also, Mumbai International Airport Private Limited. (2010) 7, I'm sorry, 2010 7 SCC 417. There are 13 to 27. In para 16, my lord, you will also kindly see that Reliance was placed.
Yeah.
The Reliance Council, for that Kasturi's case has been discussed, my lord, in para 16. 17 को है। The learned counsel for the first respondent, on the other hand, submitted that the decision in Sumit Bhai is not good law in view of the earlier decision of three-bench decision in Kasturi. Then, my lord, Kasturi has been discussed. Then, my lord, para 21 is important. Para 18, my lord, says, Kasturi's court reiterated that position that necessary parties and proprietors alone seek to be impeded as party to suit for a specific performance. This court held that necessary parties are those in whose absence no degree can be passed by the court, or those persons against whom there is a right to some relief in respect of the controversy involved in the proceeding, and that the proper parties are those whose presence before the court would be necessary in order to enable the court effectively and completely to educate and settle all the questions involved in the suit, although no relief in this suit. That is paragraph 12 of the my lord Kasturi. Referring to the suit for specific performance, this court in Kasturi held that the following persons are to be considered as necessary party: the parties to the contract which sought to be enforced, or their legal representative, a transfer of property which is the subject matter of the contract. This court also explained that a person who has a direct interest in the subject matter of the suit of a specific professional agreement of sale may be implicated as a proper party on an application under Order 110 CP. This is important. This court concluded that a purchaser of the suit property subsequent to the suit agreement would be necessary party, as he would be affected if he has purchased it with or without notice to the contract, but a person who claims a title adverse to the defendant vendor will not be a necessary party. The first respondent contended that Kasturi held that a person claiming a title adverse to the first respondent contended that Kasturi held that a person claiming a title adverse to the title of defendant vendor could not be impeded, but the effect of Sumit Bhai would be that such person could be impeded, and that therefore the decision in Sumit Bhai is contrary to the legal larger bench decision in Kasturi. That question was raised in this case, my lord. Now, on a careful consideration, now this is important, we find that there is no conflict between the two decisions. The two decisions were dealing with different situations requiring application of different facets of sub-rule 2 of Rule 10 of Order 1. This is made clear in Sumit Bhai itself. It was observed that every judgment must be governed and qualified by a particular fact of the case in which such expressions are to be found. That a little difference in facts or additional facts may make a lot of difference in the precedential value of a decision, that even a single significant detail may alter the entire aspect, that there is always peril in treating the words of a judgment as though they were words in a legislative enactment, and it is to be remembered that judicial utterances are made in the setting of facts of a particular case. The decision in Ramesh Bhai so-and-so and Anil Kumar also explains in what circumstances persons may be added as party. Now 25. This is important, Miller. 25 and 26. Miller got it. In other words, the court has the discretion. Now, this is very important. The court has a discretion to allow or reject an application of a person claiming to a party, depending upon the facts and circumstances, and no person has a right to insist that he should be impeded as party merely because he is a proper party. If the principles relating to the impediment are kept in view, then the purported divergence in two decisions will be found to be non-existent. The observations in Kasturi and Sumit Bhai are with reference to the facts and circumstances of the respective cases. In Kasturi too, this court held that in suit for specific performance, only parties to the contract or any legal representative of the party to contract or a transferee from a party to the contract are necessary parties. In Sumit Bhai, this court held that a person having semblance of a title can be considered as a proper party. Sumit Bhai did not lay down any proposition that anyone claiming to have any semblance of title is necessary party. Nor did Kasturi lay down that no one other than the parties to the contract and their legal representative transfer can be impeded even as a proper party. So, my lord, ultimately, my lord, it will depend on the facts and circumstances what plea is there. My lord, I have the entire material placed before the trial court. And trial court having come to the conclusion that he is not a stranger, my lord, he is not a stranger who is coming to, my lord, who is coming to the court seeking, my lord, impediment. My lord will write for me.
over your court.
No, I'll come to. If the lordship sees a continue, then I can continue, my lordship probably is 110, your lordship.
At 2 p.m.
2 p.m.
Yes.
I have shown these three decisions. 2005 has been distinguished in these two decisions of 2007 and 2010. And even in 2005 also, paragraph 12, I have read. It may not, I have some interest. It cannot be said that I am totally stranger to the entire matter. And so lordship kindly see, their friend. I think record is also there, but I'm showing your lordship. It will be easier for entire record is here, but from their friend I'm giving, your lordship will kindly see. My lord, your lordship will kindly come to page 8, page 9, my lord. I'm not reading the other, my lord. It was their friend. Because my suit was filed earlier. Page 9, my lord. I have paginated it, my lord, page 9. Page 9, paragraph 13 of their friend.
Yes.
May I read, my lord? That while the plaintiff, after taking possession of the properties of defendant number 1 when managing, administrating and running the free state of defendant number 8 in Sikna, for Mr. Agarwal Tea Company of Jorhat, who had all knowledge of purchasing the defendant number 8 from the defendant 1 to 7, filed a title suit on Sikna, white so and so, honorable court, claiming that the state defendant number 1 has a liability of so and so payable to them. While claiming for payment of their state liability in their aforesaid suit, they most illegally imputed the plaintiff. Most illegally imputed the plaintiff as well as the pro forma defendant 9 therein, claiming that the property of defendant is valued not less than 5 crores and the same has been sold out to the plaintiff in a throw-over price, and that the agreement was executed without free consent and the same was made with undue influence, and nothing has been mentioned in the agreement as regards service status of the employee on sale of the defendant act to the same is liable to be cancelled, etc. In the state suit, so and so, plaintiff has paid for a declaration that the agreement was void, further sought injunction restraining so and so. Then they have stated about the injunction that was rejected on 34. That fact they have stated. This is one. And now, my lord, so far their pay is concerned, at page 13. They have paid for, my lord, executing a sale deed, my lord, in their favor. Page 13, para 25, A and B. Now, next, my lord, my paid is also there. Lord, your lordship will kindly come to page 22. My plaint at para 5. My lord, in the middle, my lord.
30.
22, my lord. Page 22, para 5.
Yes.
That the free state has been stated earlier has been claiming or less for 4 or 5 years and had incurred heavy liabilities in the market, including in favor of the plaintiff. But what I am trying to say, my lord, that the liability was in respect of, Duliwam Tea Estate, my lord, that company, not the individual, Mr. Saikiaj, are not individually liable. The liability in favor of the plaintiff alone extends to so and so. As on Itna, it is inconceivable that there would be no other liabilities in favor of other private parties in the market. No provision has been made for payment of liabilities in favor of the plaintiff. Now, my lord, your lordship can skip from the list of statutory liabilities. It appears that no provision has been made for liabilities on account of cost, sales, agriculture, income tax, shelter tax. The valuation of the tea estate, including the factory, should not be less than 5 crores. To agree to sell it by the vendor without making any provision for payment of liabilities in favor of the plaintiff is nothing but an attempt to defraud the plaintiff and all the creditors by all the three parties to the agreement. The confirming party, that is defendant number 9, appears to have got the deal struck at its throwaway price, protecting its own interest and cost of other creditors. Well, the 9 also laid had some liability. He also paid some money. Eastern Tea Brokers. Further, while at one place it is provided that after ascertaining of the dues of the defendant, the entire dues shall be paid. At the time of another place it is provided that 25 crores, and these are not relevant here. Now in page 24, I am reading the fourth line. There is no forfeiture clause also in the said agreement for sale, nor there is any provision for specific performance of the said agreement. Then skipping 2 lines more, the defendant number 1 by his rewriting dated so and so to the plaintiff and specifically stated there, the state shall not be disposed of before clearing their dues. But now to speak of clearing the dues even without making any provision for payment of the state has been agreed to be sold at a lower price. The state agreement for sale dated so and so is in violation of the state writing undertaking and all that. And in my suit, the pair, if your lordship kindly turn to page 28. The prayer portion, decree for declaration that agreement for sale dated is illegal, inappropriate, conceivable, and void, and that it cannot be acted upon. And cancellation of the said agreement. Now, I have annexed, all these are not very much required. The defendant number 8 is the petitioner. He has also filed a written statement in that. That your lordship will find it. I am not reading that. Your lordship will find that at page 62 onwards. My lord. To page 70. Page 70, para 6. Last part. All of a sudden, the defendant was surprised to receive notice of above suit and ex parte interim order. The defendant has reason to believe that said suit has been filed in collusion in connivance with some of the defendants, in particular defendant number 1 with the oblique and ulterior motive. So, my lord, these are the facts. My lord, all these facts will show, my lord, that my lord, I am not an stranger. My lord, had it been a stranger, my lord, definitely, my lord, I would have no right to, my lord, be implicated in this. And in view of the decisions, my lord, which I have relied on, and even in, my lord, which the decision which they are relying on of 2005, if your lordship will kindly see that I am, my lord, a necessary party to this. My lord, I am even not necessary, my lord, I am a proper party to this. Because my interest is involved. I have to protect my right and my interest. And my lord, no prejudice will be caused to them. Your lordship will kindly consider this aspect of the matter. This is very important. And my lord, let us suppose that, my lord, my suit is decreed. My suit is decreed. His suit will be infected. His suit is decreed. For all practical purpose, my suit will be also infected. Though my lord has said, my lord, that I can, my lord, my degree can be not executed against that. My lord, the tea garden is the only property, my lord.
Where is that pleading?
Huh?
Where is that pleading?
Yes, my lord, your lordship will find in paragraph 5. And that fact, the defendant number 8, that petitioner have denied in their written statement. মাফ করা নাই কিন্তু তাহাতে রিপ্লাই করেছে because they have denied it. That fact has been denied. I'll point out to my lord. It is there, my lord, because they have, my lord, I'm just drawing their attention, you know.
Any other point?
Huh?
Any other point?
Any other point, my lord? They have, my lord, only your lordship. That point I'll point it out to your lordship. My lord, paragraph, page 74, my lord. Paragraph 5 will reply you. My lord, dependent number 8 has stated when replying to paragraph 5. My lord, page 74. My lord, from that paragraph, last 6 line from bottom, my lord. The alleged letter allegedly dated 5th December appears to have been brought into existence in collusion, conspiracy, and convenience with the defendant number 3. It is denied that the defendant numbers 1 to 7 have no other property to pay of the plaintiff's alleged due as alleged or at all. Something somewhere said, it's not there. So, Lord, I'll just find out, my lord. I couldn't find it out. I'll tell. Now, Lord, these are the factual positions. Now, my lord, my another submission is that my lord, the trial court has exercised its discretion on the basis of the materials on record and come to a conclusion that I am not a stranger. My lord, this finding is, my lord, based on facts, and my lord, that has been placed by them also, and I have also placed before my lord that I am not a stranger. I have some interest on the property. It's not that I am totally a stranger. I have nothing to do with, my lord. I am entitled to 1 crore something, my lord, 1 crore 50 lakhs and all. Plus interest and other things will be there. Secondly, in view of that, clause section 19 A and E would not apply.
No, sir, Agorda, you submit in a so specific performance of contract.
Yes, my lord.
What is the relief being sought for?
My lord?
What is the relief?
The relief they are asking for, my lord, by making a sale deed, my lord, in their favor. And my lord, para 13 I have shown, my lord. They are speaking about my suit also. So, my lord, what my plea here, if my lord, those pleas are not taken in that suit, my lord, I will not be able to cross-examine them in this. And he may not be available, he may not give his evidence in that other suit also. Because he is a different, he may keep mum, my lord. So, these are the difficulties, my lord. That's what, my lord, his implement is necessary. So unless and until I am impeded, I will not be able to file any written statement. I will not be able to file, my lord. That opportunity will not be given. Okay. And once suit is decreed, my lord, I am relying on some decision. It was there. It was there. My lord, on 227. And I am relying on 3 decisions on 227, my lord. My lord, my lord, I'll come to Surya Dev Rai, versus Ramchandra Rai and others. And I'll take my lord to directly to paragraph 38. Lord, page 694.
Paragraph number?
Paragraph 38, my lord. Your lordship will kindly come to page 65695. 38.4. My lord, 6954. Supervisory jurisdiction article 227 of the Constitution is exercised for keeping the subordinate courts within the bounds of their jurisdiction. When a subordinate court has assumed a jurisdiction which it does not have, or failed to exercise a jurisdiction which it does have, or the jurisdiction, though available, is being exercised by the court in a manner not permitted by law, and failure of justice or grave justice has occurred thereby, the High Court may step exercise its supervisory jurisdiction. Then 6, my lord, a patent error is an error which is self-evident, which can be perceived or demonstrated without involving any lengthy or complicated argument or a long-drawn process of reasoning, where 2 inferences are reasonably possible, and the subordinate court has chosen to take one view. The error cannot be called a gross patent. What my submission is here, my lord, that on the basis of the materials on record, whatever finding the learned trial court has come, my lord, it will not come within the purview of lord gross patent illegality. The other 2 decisions also in my lord, second plate 2005-11 SCC 578 para 3, having heard the learned counsel for the parties, my lord, got it.
Yes.
Having heard the learned counsel for the, we are satisfied that the order passed by the High Court cannot be sustained. The trial court had exercised its discretion and assigned reasons for permitting implement in exercise of limited jurisdiction conferred by Article 20. The High Court should not have interfered with the discretion exercised by the trial. A very small one-page judgment order. Then my lord, another decision. The next decision is Jai Singh versus MCD, para 15. My lord, I am reading the last few lines from bottom, my lord. It will be line about 6 line. It is, however, well remembered that well-known adapt that greater the power, greater the care and caution of exercise of High Court is therefore accepted to exercise wide powers with great care, caution and clarity. The exercise of jurisdiction must be within well-recognized constant. It can be exercised like a so and so to correct all errors of judgment of a court or tribunal acting within the limits of jurisdiction. The correctional jurisdiction can be exercised in cases where orders has been passed in grave dereliction of duty or in flagrant abuse of fundamental principles of law. These last 2 lines, my lord, I am emphasizing. This correctional jurisdiction can be exercised in cases where orders have been passed in grave dereliction of duty or in flagrant abuse of fundamental principles of law. So, my lord, my humble submission that my lord, my lord, I was referring to my lord Paras, lordship the plan, para 7, if your lordship kindly page 26. Compilation, lord, compilation. Just that fact that
Paragraph number or page number?
Page 26, my lord. Para 7.
Yes.
My lord, your lordship will kindly not read the entire, or a line about 10. 20 would not be able to realize anything. My lord, your lordship got it, my lord, in the middle, my lord. Or should I read, my lord, entire? Your lordship got it. the plaintiff would not be able to realize anything from defendant number 1 to 7, who do not have any property to satisfy the plaintiff's claim, and from defendant number 8, who is, as per the agreement, is not taking over the liabilities of the defendant number 1 to 7. Now, this is the position. The defendant number 8, who is the petitioner before my lord, he has denied this fact in the my humble submission, is that the learned trial court has right to exercise his discretion and pass the order, impeding the party, and it does not call for any interference.
Can I reply? Yes, sir. Any topic?
No, my lord, because in the indictment, I have nothing to say because the only thing is that I have also challenged, I have filed a counter claim with the suit filed by the petitioner hearing, saying that that agreement is null and void, seeking a declaration that the agreement is null and void. So in the circumstances, whether the application filed by the respondent number 1 seeking the same relief what has been sought by the main defendant, or not.
This fact I pointed out to my lord, that they have taken the plea, they have filed a counterclaim, and they say that this entire agreement is null and void.
Only on the point of reply, my lord, so far as the judgment of 2007 is concerned, my lord, Sumit by Paras Finance Company, the custody, my lord, the ratio laid in the custody, my lord, that case judgment has been, my lord, distinguished. Distinguished, my lord, basically is always on the facts. In the custody, fact was that the my lord, applicants, my lord, they were, my lord, adversely possessing the land. So court says, my lord, the third party to the suit cannot be implicated. Now, in so far as the Sumit Bhai is concerned, there, my lord, the application under Order 1 Rule 10 was filed by the legal heirs of one of the party to the suit. So therefore, court says that custody ratio, my lord, will not be applicable because he, my lord, they sought to, my lord, substitute or file the application on the basis of the defendant or the person who are already a defendant in the suit. So that has been distinguished. And the second case, my lord, what has been referred, the 2010 7 SEC, Mumbai International Airport. Well, here the distinction between the custody as well as Sumit Bhai has been clearly laid down. And in this case, 2010 7 SEC 417 Mumbai International Airport, their facts was that Airport Authority India, they have given the airport on lease to the appellant, Mumbai Airport, Chhatrapati Shivaji Airport. But there is a clause that 31,000 square meter of the land will not be included in the lease. That may be included if the a pending suit, which was between the Air India Authority and another third party was pending, subject to the decision that may be included. So the appellant filed an application in that suit to be implemented as a party, and ultimately, the court has distinguished all these cases because that all the cases has to be just considering the fact of each case. And ultimately, in this case also, in paragraph 27, the court has said he is not a necessary party.
Paragraph number?
Okay, well, factually, I have already said, no, the facts is in paragraph 5 and 6, 5, 6 and 7. Is the facts. And the distinction that has been, my lord, brought, paragraph 20.
Yes.
The first respondent contended that Kasturi held that a person claiming a title adverse to the title of the defendant vendor could not be implemented, but the effect of Sumit Bhai would be that such a person could be implemented, and therefore the decision in Sumit Bhai is contrary to the larger bench decision Kasturi. On a careful consideration, we find there is no conflict between two decisions. The two decisions were dealing with different situations requiring application of different facts of facets of sub-rule 2 of Rule 10 of Order 1. This is made clear in Sumit Bhai itself. It was observed that every judgment must be governed and qualified by the particular facts of the case in which such expressions are to be found. That a little difference in facts or additional fact may make a lot of difference in the precedential value of the decision, and that even a single significant detail may alter the entire aspect. That there is always a peril in treating the words of a judgment as though they were words in legislative enactment, and it is to be remembered that judicial utterances are made in the setting of the facts of the particular case. Then your Lordship may come to paragraph 26. If the principle relating to implementation are kept in view, then the purported divergence in the two decisions will be found to be non-existent. The observation in Kasturi and Sumit are with reference to the facts and circumstances of respective cases. Kasturi, this court held that in a suit for a specific purpose, only the parties to the contract or any legal representative of a party to the contract or a transferee from a party to the contract are necessary parties. In Sumit Bhai, this court held that a person having semblance a title can be considered as a proper party. Sumit Bhai did not lay down any proposition anymore claiming to have any semblance of title is a necessary party, nor did Kasturi lay down that no one other than the parties to the contract and their legal representative therein can be implemented even as a proper party. Because in Sumit Bhai, my lord, as I the facts will also will find, Sumit Bhai, the legal heirs filed that application, who was already a party to the suit. This is personal. Then in 27, on a careful examination of the facts of the case, we find that the appellant is neither a necessary party nor a proper party. As noticed above, the appellant is neither a purchaser nor the lease of the suit property and has no right, title or interest therein. The first respondent plaintiff in the suit has not sought any relief against the appellant. The presence of the appellant is not necessary for passing an effective decree in a suit for a specific performance, nor is its presence necessary for complete and effective adjudication of the matter in issue in the suit for a specific performance filed by the first respondent plaintiff against AI. A person who expects to get a lease from the defendant in a suit for a specific performance in the event of the suit being dismissed cannot be said to be a person having some semblance of title in the property in dispute. That is the ultimate finding of the court in that case. So these two, my lord, doesn't help the other side, my lord. And so far as the decision of the trial court with regard to the stranger, that he is not a stranger. A stranger has to be referred to the subject matter of the suit. The subject matter of the suit is the agreement. Where he is not a party, he doesn't have any right. And lastly, regarding the maintainability, first of all, this petition was admitted without their objection.
No, I am not argued on maintainability.
Of course, last year I have argued on the maintainability.
I am not argued on maintainability.
That has been argued. This has been without any objection. And the petition was admitted. Today is fixed for hearing. That is one thing. And secondly, even the Surya Devi case, it has been clearly said, jurisdictions does vested, but acted in a manner not permissible under the law. Now, Lordship, I have taken a Lordship to the decision of the trial court. Just recited what had been stated by the petitioner in the petition, so far as my objection has not at all been recorded. And apart from that, the ratio laid down in the custody case was in, my lord, place, my lord. That judgment, my lord, is a law for the purpose of deciding the, my lord, issue. That has not been, my lord, taken into consider, not at all referred to. That is the case.
But nobody in the, before the trial court, nobody placed any decision, my lord. Lordship will kindly see the trial court.
No, no,
had
this
it
is a
been a-
law, my
had-
lord.
no, no, I'm not saying, my lord. Had it been a case, that, my lord, somebody has placed this decision and the trial court has not considered, my lord, had it to be a different thing.
That the law is
Anyway, my
known
lord,
to
your lordship
everyone.
will-
That is the presumption. Law is known to everyone. My lord. It is
I may not be a necessary party, but I am a proper party, my lord. That is, my lord.
not at all, my lord. Not at all. It's not.
Or, sir, it is a record. Or, Agora, or, oh,
Hello?
oh,
I'm there.
And
sir, or on that number.
I've given the number.
Argument for that order.
my lord.
Lord, I have one matter, item number 16. I may be, my lord, accommodated this for the day in 16. Maybe taken up on a different date, my lord.
But the absence of the other.
Lordship, my lord, I'll mention it. Find little accommodation by the court.
So that's all right. I have no problem. Accommodation. But
Look,
the problem is that you have of the other.
That's all. Let item be called when I'll make the prayer.
With your lordship. My lord friend had filed a I for release of the amount deposited. 50% has been deposited. Lordship, I have no objection to release of some amount, but 50% may be high in this case. So when my lord friend will agree, 50% of would be about 4 lakhs, 2 lakhs may be released. They have challenged the dependency of the claimant. The deceased was 40-year-old and the claimant is a 45-year-old.
Amount deposited before the registry of this court.
4
Yes.
lakhs something, Lordship.
4 lakhs.
4 lakhs, 2,000.
2 lakhs may be released, Lordship.
Of the awarded amount.
Awarded amount is 8 lakhs.
2 lakhs may be released, Lordship, because finally it may not be.
2 lakh is.
Sir, some, see,
Lordship,
it might legislative depends on behind the act.
Lordship, I'm just saying, I'll make a very humble submission, a very short and simple, humble submission. Lordship. It is according to Lordship, Pranay Sethi, Lordship, where the deceased is a bachelor, the siblings are not considered as dependent, only parents are considered dependent. Even mother is only considered. Here the equation is this person who died is a bachelor, and the only claimant is a 45-year-old married major brother. The question of dependency, Lordship, compensation assessed either in terms of dependency or in terms of, Lordship, loss to estate. There is a separate formula also for the loss to estate. In this case, Lordship, I'm not saying he's not entitled to anything, he's the elder brother. But it will not be same as the question of loss of dependency. It's a case of loss to estate, whatever he has occurred to the individual. For a moment, for a moment, Lordship, 2 lakhs may be released. And matter may fix for hearing next month also. If he's entitled to full 8 lakhs, because LCR has been received, Lord. But my early application, so some amount may be released and matter may be decided at an early date.
No, Mr. Sami, let's take the amount. You will execute on both.
4 lakhs. Let him execute upon it. He's not entitled to it because finally.
Or Mr. It's application filed by Mr. Khan.
And for a Lordship, a respondent number, applicant respondent number 1.
This IA number 2201.
Yes.
Third M1. party number. Sir. Yes, you call SNN number 2. Or your good name is Aras. Aras. Ratwa. Application under section 1 of the application of disbursing. Now, for disbursement of 50% of the awarded amount was deposited to the ratio for favor of the applicant. Drug claimant, drug respondent number 1. Sir, something ordered counted for the FLA. Drug opposite party number 1. Has opposed the on the ground that uh, applicant is not a dependent.
It's not a dependent.
Upon basic. And as such, he is not entitled to compensation under the head loss of dependency. However, taking the party to be taken without subject power to allow the subject of for the subject on executing indemnity terms of IX.
Yes. Permanent.
Yes. I think also not available. Not available. Third, the sunsetting learning for the FLN and it is for the of to the name of what UP Sharma is like the name of Mr. Sharma like cost cost. It's considered after
vacation.
after
After 16. Yeah.
The second appeal, my lord, the concurrence finding is there, my lord. Under Assam Temporary Settled Areas Tenancy Act 1971.
whether all the parties are represented. Correct.
My lord, for the main
We are representing 1.1 lordship. We are the plaintiffs, lordship. And government is also there, lord. Others,
Okay, respondents are there.
yes, lordship, 22. Others are pro forma, lordship.
government.
Service complete, so matter was fixed for hearing, lordship. And it's a old pending case, lordship, 2016 matter.
Subsequent question of law framed my lord on 22/17.
So there is only one substantial question of law.
One, my lord, and any other subsection of law, I will, my lord, submit on perversity, my. Because, my
It
lord,
has not been formulated.
six witness, my lord, three PWs are there and four DWs are there. There, these were not discussed, my lord, in the judgments.
Pardon?
The evidences of the witnesses not discussed, my lord.
No, perversity, on the point of perversity, no substantial question of law is.
My lord, there is a second subsection of law. I may, my lord, any other subsection of law that may be raised at the time of hearing. I think, my lord, the second. On that, my lord, I may my lord, submit on the perversity, my lord.
Yes, any objection?
Lordship, if any new substantial question of law is formulated today, then Lordship, some time may be given to answer that question. Lordship, first they have to satisfy whether this substantial question of law is there or not, Lordship. It says, Lordship, we are the plaintiffs and their sale deed is void, Lordship.
In fact, my lord, we are the defendant and we also, my lord, submitted the documents that we are also tenant of the same my landlord, my lord. They are plaintiff, they are also submitted document, they are the tenants of the landlord. And we being tenants, we have purchased from the landlord, my lord, one of the landlord. And that landlord in the cross-examination of the PW1, the PW plaintiff admitted that my vendor is also one of the pattada, of the same patta, my lord. So, my lord, that aspect is not considered, for which the perversity is to be required, my lord. That certain question of law will come, my lord. For which
Lordship, let him read the judgment first, then your Lordship, if satisfied, then there is perversity, then your Lordship may formulate.
Before going to the judgment, I have to go to the evidence, my lord. Because in the evidence, there is the admission of the plaintiff that my landlord, my vendor is also a pattadar of the same patta, my lord. One of the pattadar, the landlord from whom I have purchased, my lord.
Our case is that Lordship, from the predecessor of that pattadar, we are the riots, Lordship, under that pattadar. And that Jodhar's son, defendant number 4, sold out the land to defendant number 1. Both the courts held that when there is a riot under original pattadar and there is no objection, that then defendant number 4 have no right, Lordship, to sell that land to defendant number 1. Let him read the judgments first, your Lordship.
No, your objective that the court below has not considered the evidence of PW.
Yes. PW1, my lord, there is admission on the part of the my lord. I have also annexed, my lord, this, my lord, page number 81. In my memo of appeal, I have annexed the evidence of the PW1. And there is, he has specifically admitted that my landlord is also a pattadar of the same land, my lord. Page number 81, my lord, I had in the memo of appeal, I have annexed this.
And the evidence of which witnesses were not considered.
Evidence, my lord, DW, I have DW 1, 2, 2, 3, 4, my lord. 2 is the sub-registrar of my sale deed. 3 is the my lord, one of the witness of the deed, my lord, attesting witness. Then 4 is the, my lord, one of the neighbor, my lord. Then he is also one of the, my lord, here, my lord, legal here. Judgment, my lord, page number, appellate judgment, my lord, page number 9.
That trial court has considered the same argument.
No, my lord, no. Page number, my lord, 30, 30. Only on the basis of Khatian, my lord, both the court passed the judgment. Page number 30, my lord.
What is the relevant file?
11, my lord, page number 36, my lord. Page number 33, issue number 4, my lord.
Paragraph number?
My lord, second paragraph, my lord, issue number 4, page number 36, my lord. Trial court judgment.
Trial court or appellate court?
My lord, this is trial court judgment, my lord, page number 36. May I read the paragraph, my lord? 2 paragraphs. My lord, this issue is relates to the right of the plaintiff as tenant over the suit land, and therefore the burden lies upon the shoulder of the plaintiff to prove this issue. The plaintiff side adduced 3 witnesses and 7 number of documents. The plaintiff is examined as PW1, and in support of his claim, he submitted the evidence on affidavit as a form of oral evidence. He submitted that he took tenancy settlement of the suit land and other land from Rakesh Chandra Das and Rabindra Chandra Das. Rakesh Chandra Das is my father, man. And Rabindra Chandra Das. Rakesh Chandra and Rabindra are both the brothers. In 1368 BS, and in the same year, the Pattadar recognized his tenancy settlement of the entire land he had purchased and issued the final Khatian number 468, granting the rent receipt 27/12/1377. That is equivalent to 1971. He submitted the original final Khatian 468, which is proved as Exhibit 1, and also submitted the original rent receipt 27/12/1377 BS, which is proved as Exhibit 2. The Exhibit 2 was issued by the Pattadar, who signed therein in his presence. The Pattadar is my father, man. He proved the signature of the Pattadar of late Rakesh Das by Exhibit 2.1. The plaintiff PW1 also submitted that the exhibit number 1 was finally published in 1975 with the knowledge of all concerned, including the defendant, and he is in the possession of the suit land along with the other land. On perusal of both documents, it is found that Exhibit 1 is the final Khatian issued in the name of plaintiff as tenant by the Pattadar Sri Rabindra Chandra Das. Rabindra Chandra Das is the brother of my vendor's father. That is my vendor's uncle, and 5 others. These 5 others he admitted, my lord, in the cross-examination, my lord, where my vendor's name is there, my lord. The suit land bearing dag number 1097, measuring about 1 biga 14 kata 4 sota, is found included in the said Khatian. On perusal of Exhibit 2, it is seen that the said Exhibit 2 is also the original receipt being issued by Pattadar Sri Rakesh Das, issued on so and so. On the other hand, to deny the case of the plaintiff, the defendant in their evidence submitted that the suit land is exclusively belong to the father of the defendant number 4. Defendant number 4 is my vendor, and my landlord. Bimalendu Das, the son of the plaintiff's landlord. By way of periodic Firas Patta number 1 of Baniargul Mouza, and after the death of his father, he became the owner of the suit land. The defendant Sri Amoresh Chandra Das also denied that late Robindra Chandra was the pattadar of the said suit, but the name of the plaintiff was wrongly recorded in Exhibit 1. On bare perusal of Exhibit 1, it is seen that name of Robindra Das was entered into the said final Khatian as pattadar along with 5 others. Hence, 5 others means my lord, including my landlord and vendor's name, my lord, Bimalendu Das. Hence, the contention raised by the defendant number DW1 to the fact that Robindra Chandra Das was not the pattadar of Khatian number 468 cannot be accepted. In regard of wrong entry of the name of the plaintiff in Exhibit 1, that is Khatian number 468, no cogent evidence has been cited by the defendant side. However, the defendant side filed Xerox copy of periodic Firas Patta number 1 issued in favor of his father late Rakesh Chandra Das, and some of the rent receipt issued by said Rakesh Chandra Das, but has not been examined with the original. Being the mere Xerox copy, these documents carried no evidentiary value at all. If we carefully and comparatively scrutinize these documents, then it appears that the documents submitted by the plaintiff side are original documents, and the documents submitted by defendant side are mere Xerox copies. As such, the documents of the plaintiffs have high evidentiary value with respect to the documents submitted by defendant. I also perused the schedule and boundary submitted by the defendant in case of denial, the schedule and boundary of the plaintiff, and found that both the schedule and the boundary are the same without having any contradiction. In view of the above discussion reasoning, it appears that the plaintiff was the tenant under the pattadar, Robindra Chandra Das and others, and his name was rightly included in the final Khatian number 468. Accordingly, this issue is decided in favor of the plaintiff and against the defendant. This is the issue regarding the that the plaintiff is a tenant. So none of the witnesses, my lord, mentioned in these findings, my lord. The second issue is regarding my purchase deed, my lord. Issue number 5. This issue relates to whether the Kobola deed number 3042 27/2006 executed by one Bimalendu Das in favor of the defendant number 1, Sri Amoresh Das, valid or not. This Bimalendu Das is, my lord, the pattadar that is admitted by the plaintiff, my lord, in his evidence. That out of the 5, 1 is this Bimalendu Das. To establish this issue in favor, the plaintiff submitted Exhibit 1 to Exhibit 5. Exhibit 5 is the, my lord, this sale deed, my lord, my purchase deed. In regard to Exhibit 1 and 2, it has already been discussed in issue number 4 and accordingly decided in favor of the plaintiff. Exhibit 5 is the alleged sale deed 3042 executed by the defendant number 4 in favor of defendant number 1 on 27/06, which is challenged by the plaintiff. On bare perusal of the alleged deed, it is seen that the defendant number 4, Bimalendu Das, sold out the suit land to the defendant number 1, Sri Amoresh Das, claiming his right of inheritance from his father, Rakesh Das. But his right of inheritance is challenged by the plaintiff, submitting that he is the tenant of the said suit land, which had been settled by the predecessor of the defendant number 4. To prove his tenancy under such pattadar, he has submitted Exhibit 1 and Exhibit 2, which is found correct and authentic. Exhibit 1 is his Khatian, my lord. Exhibit 2 is one of his Harog, that is, my lord, rent payment receipt. So only one receipt he exhibited and the Khatian, which is found correct and authentic. But the defendant could not submit any documentary evidence except some Xerox paper in respect of his right of inheritance. the defendant side would not show any, so regarding right of inheritance, my lord, it is not to be proved because he has admitted, my lord. He has admitted that I am the son of the Rakesh Chandra, and he has admitted I am one of the Pattadar, my lord, of the same Patta. So it need not be proved, my lord. Was exclusive, whom he claims right of inheritance was the exclusive owner of the suit land. From the pleadings documents submitted by the either party and the oral evidence, it appears that the plaintiff was recognized as tenant and his name was entered into the final khotiyan on the basis of such tenancy right, and since then he has been in possession of the suit land prior to the registration of the alleged deed. Since the suit land had already been settled upon plaintiff and his right was not terminated any provision of law, his right cannot be interfered by way of selling the suit land by anybody else. As such, it can be held that the defendant number 4 sold out the suit land by its own without having any right title over it. Accordingly, this issue is decided in his favor. So, none of the witnesses is discussed, my lord, by the trial court, my lord. Now, may I come to the appellate judgment, my lord, page number 9. So, my lord, page number 15 is the relevant page, my lord. Page number 15 of the appellate judgment. The issues, my lord, of Learned Court, Learned Trial Court mentioned in this page number 15, my lord. Number 1 was whether there was any cause of action. 2 was whether the suit is maintainable. 3, whether barred by law of limitation. And 4, whether the plaintiff has tenancy right. 5, regarding the, my lord, Kabula, my purchase deed, valid or not. And second, the relief, my lord. Paragraph number 5, my lord, plaintiff examined 3 witnesses and exhibited certain documents. On the other hand, defendant side accused 4 witnesses and exhibited number of documents. Learned Munshi passed the impugned judgment. So next, my lord, point. The Learned Appellate Court framed 2 points, my lord. Paragraph 9. From the materials available on record, the real question in controversy between the parties appears to be whether the plaintiff took tenancy settlement of the suit land from his original owner in the year 1368 BS. Whether the sale deed number so and so executed by defendant number 4 in favor of defendant 1 in respect of suit land in the year is valid. So these 2 points in the trial court's issue number 4 and 5 is formulated by the Learned Appellate Court. Now, my lord, point number 1 regarding the tenancy, my lord. Page number 16, my lord. Plaintiff, in order to substantiate his claim that he took tenancy settlement of the suit measuring 1 biga 14 gata 4 sota covered by DAG number 1097, exhibited final Khotiyan 468 as exhibit 1. I have perused the aforesaid final Khotiyan, and on perusal of the aforesaid Khotiyan, it indeed appeared that the suit land covered by DAG number 1097 is settled with the plaintiff along with other land covered by different DAGs measuring several bigas of land by his original owner, including Rakesh Chandra Das and Rabindra Das, as claimed by plaintiff. Now, if we draw our attention to section 58(5) of the Assam Temporary Settled Areas Tenancy Act, we will find that it categorically stated that every entry in record of rights finally published shall be conclusive evidence of the matter referred to in such entry and shall be presumed to be correct until it proved by evidence to be incorrect. It will be incorrect. Further, the Honorable Guwahati High Court also in the case of so and so states that every entry in the records of right finally published shall be conclusive evidence of the matter referred to in such entry and shall be presumed to be correct unless it is proved by evidence to be incorrect. Burden of proof that such entry incorrect shall be on the person so ascertained. Now, that being position of law, I am of the considered opinion that burden of proving that the final question is incorrect rests upon the defendant when the statutory presumption is in favor of the plaintiff as Exhibit 1 document, and we know that presumption makes a prima facie case for a party in whose favor exists. Now let us see whether defendant has discharged his liability. To find out the answer, let us discuss WS of the defendant at the outset. The perusal of WS submitted by defendant number 1 to 4 reveals that defendant number 1 to 4 in para 8 of their WS also admitted the fact that the name of the plaintiff is recorded in final Qatyan number 468 against the Switzerland. Nowhere they took plea that it was recorded wrongly in the final Qatyan and same was issued collusively by defendant number 5 to 7. This is perverse, my lord. This is not their man. Though it is mentioned in WS, my lord, page number 63, my lord, may I go, my lord, paragraph. The WS and your evidence, my lord, the Qatyan is fake, we have mentioned, my lord.
Page number 63.
63,
Paragraph number.
my lord. Paragraph 8, page number 62 starts of my WS, my lord. Learned Cabinet Court held that we have admitted that and we have not challenged the Qatyan, my lord. From paragraph 60, page number 63, from second line, may I read? Rabindra Chandra Das had no right title or possession. Rabindra Das is he from whom he has allegedly taken the Qatyan, my lord. Rabindra Chandra Das had no right title or possession into the Switzerland. The plaintiff was never settled with the Switzerland by the said land lord owner Rakesh Chandra Das. The name of the plaintiff was wrongly recorded in the final Qatyan number 468. It is collusively issued in his favor by the defendant number 5 and 7. Said Qatyan does not confer any right title and plaintiff, my lord, but the learned appellate court held, my lord, that we have admitted that that the name of the page number 16, my lord, that the name of the plaintiff is recorded in the final Qatyan against the Switzerland. Nowhere took the plea of it was recorded wrongly in the final Qatyan. So this finding is a perverse finding, my lord. Page number 17, I will come, my lord. But if we peruse the entire materials available on record, we will find that there is no iota of evidence, be it oral or documentary, to substantiate their claim that the name of plaintiff is wrongly recorded. So no evidence is discussed, my lord. 4 out of the 4 of the witnesses, no one is discussed, my lord, in both the trial and judgment. How this appellate court came into, my lord, this finding, my lord, that no iota of evidence, be oral or documentary, substantiate their claim that the name of plaintiff is wrongly recorded in the respect of the Switzerland, Exhibit 1 document, nor plaintiff was able to brought on record as to why defendant number 1 to 7 was illegally entered the name of the plaintiff number 1 in a revenue record in respect of the land. Now, in the instant case, Exhibit 1 document makes out a case and there is a severe presumption as per section so and so, some Temporary Tenancy Act in favor of the plaintiff. So, defendant is duty bound to prove the collusion and set forth the ground on the strength of which he claimed that final Qatyan was wrongly recorded. But in the instant case, materials available record disclosed that defendant miserably failed to discharge his liability. So, under such circumstances, I am of the considered opinion that presumption of law existing in favor of the plaintiff on the strength of Exhibit 1 remain undebated. And on that count, I am of the considered opinion that no option is left to the court, but is bound to take that entry made in Qatyan Exhibit 1 is correct. And to more so when the mandate of law laid down under Section 4 of the Evidence Act categorically states, whenever it is directed by the Act that court shall presume a fact, it shall regard such fact is proved unless until disproved. So in the backdrop of the above discussion, I am constrained to decide this point in the affirmative and in favor of the respondent. Without discussing any of the witnesses, my lord, none of the witnesses is discussed, my lord. That point number 2, my lord, regarding the, my lord, my purchase deed, my lord. As regard this point, let us first draw section 7 of the Transfer of Property Act, which deals with the person competent to transfer. The aforesaid section reveals that the order of disposal of transferable property, the transferor must be competent to contract and have title to the property or authority to transfer it if not his own. Now, the instant case, we have found in the discussion made in point number 1 that the tenancy settlement in respect of suit land is already been made in the year 1368 BS by the predecessor of defendant number 4 in favor of the plaintiff. So I am of the considered opinion that defendant number 4 had no title over the property as mandated by section 7 of the Transfer of Property Act to transfer the suit land. Again, in favor of defendant 1, the defendant number 4 being a person not competent to transfer cannot transfer the suit land in favor of the defendant number 1. So I am of the considered opinion that the document number 30426 executed by defendant number 4 in favor of defendant 1 is void document and inoperative. Further, if we draw our attention to the recital of the prime document of defendant number 1 exhibit A, we will find that it does not tally with the aberrament made in paragraph 8 of WS. Exhibit A is my Khothian, my lord. Exhibit A reveals that defendant number 4 claim right title interest and possession over the suit land after the death of his father, and he ordered to meet his urgent need of money, sold the said suit land and handed over. So my sorry, my lord, exhibit A is my purchase deed, my lord. Handed over the possession of the suit land, defendant number 1 on the date of execution of sale deed so and so. But the case of defendant number in para number 4 of WS is somewhat different. Para 8 reveals that defendant number 1 is an occupancy tenant of late Rakesh Chandra Das, that is the father of the defendant number 4 in respect of the suit land, and since his lifetime, defendant number 1 is continuously possessing the suit land. Now, if we believe the version of defendant in WS supported by an affidavit, then the contents of A is to be considered as false, because both the persons cannot be in possession of suit land at the same time. The contradictory aberrments of defendant WS to the recital of A document itself nullify the claim of defendant and indicates towards the fact that exhibit A document executed by defendant number 4 in respect of suit land in favor of defendant number 1 is illegal and void document. So in the light of the above discussion, I am constrained to decide this point in negative and the defendant appellant. So in the vector of discussion, I am the considered opinion that landlord municipal rightly decreed the suit. So my lord held that in the purchase deed it was mentioned that possession is handed over on the date of execution of the sale deed by the defendant number 4 to the defendant number 1, my lord. And otherwise, the defendant had claimed that he is the tenant of his vendor. So based on this, my lord, it is held to be illegal. The null and void, the sale deed is null and void, only on the ground of possession. That the defendant number 1 claimed he is a tenant of the his vendor.
So, madam, any objection?
Yes, Lordship, as because both the courts already held that, Lordship, on the basis of Exhibit 1 and Exhibit 2, plaintiff proved his case, Lordship.
So, where is the discussion of the evidence?
Lordship, on the basis of evidence, all this, after discussing my exhibits, Lordship, both the courts held that there is a, the plaintiff able to prove his case, Lordship.
No, regarding discussion of the evidence by the defendant.
No, Lordship, it was not mentioned that PW1 DW. There was no mention that it is PW1 DW1, but Lordship, from the contents of the discussions, it proved that, Lordship, from the written statement and from the statement of the DWs, the court, both the courts held that the plaintiff able to prove his suit.
Where the trial court as well as appellate court has discussed the evidence.
Lordship, which part was not discussed? Let him show that which part of the DW was not considered by both the courts, Lordship. As because, Lordship, the rent receipt which was given.
A fair perusal of the both the judgment.
Lordship.
That there was no discussion of the evidence by the
The entire case were discussed, Lordship, on the basis of material evidences and pleadings. All the discussions were made by both the courts below. Lordship, at that Khatian exhibit 1 is, Lordship, exhibited.
let there be another substantial question of law on the point of arbitration.
Then your Lordship may formulate and more time may be given to address on that, Lordship. Otherwise, Lordship, this substantial question of law is not there, Lordship. Already there was discussion by both the concurrent finding, Lordship.
Maybe.
Lord. And Lordship, that Khatian was prepared long back and as per section 58(5) of the Assam Land Revenue. Lordship, it was already created in the year 1977, Lordship. It was clearly discussed in page 16 that now if we draw our attention to section 58(5) of the Assam Temporarily Settled Areas Tenancy Act, we will find that it categorically stated that every entry in record of right finally published shall be conclusive evidence of the matter referred to in such entry and shall be presumed to be correct until it is proved by evidence to be correct. And they have not negated my exhibit 1, Lordship. There was no rebuttal evidence, only oral evidence, Lordship. They did not exhibited any document, only exhibit A, Lordship, that is a
That will be
certified copy.
considered after final hearing.
Lordship, that exhibit B, Farag was also, Lordship, issued subsequently. My Farag is dated 1977 and their Farag is dated 1982, Lordship.
Part से इंतकारी करने को थोड़ा appellant and part to करने को number
1.1 to 1.11, Lordship.
1.1 to 1.11.
11.
Any other response? So what is the response number 2, 3 and 5. 4, 5. So Mr. Porter says, do you have any objection in?
No, my lord, I do not have only one thing, my lord, hearing when my lord the coming days, my lord may have a result in mind. My lord can formulate that today. In future, the next few days, my lord, the 11 point is there. What happens is owners, they are the owners. They were the original owner. That is true. Now, what happens? And these are people, the respondents today, they were the tenants. Now, what happened after the bidding law came into play? These lands were taken up by the government, that is ceiling law. So they became the tenants to the of the government, and so the government settled the matter with them. So that is how they lost their land.
And Lordship, we have obtained the lands from his father, Lordship. When his father already given to the plaintiffs, how the son will become Patadar, Lordship.
And the tenants were in possession for 45 years. Or for about 45 years, they are tenants.
Exhibit 1 was created long back, Lordship. They did never raise any objection.
And the ceiling laws came into play in the 1970s. So those land which the tenants are holding now came to the government. And the tenants came into understanding after that with the they are paying the land revenue to the government. And the whole system, I mean,
If
after
your
the
lord,
ceiling laws, it
if your Lordship gives some time, then I may read the PW1, Lordship. Everything was the
No, we are not finally hearing the matter.
Lordship. Otherwise, his father already given the land to the plaintiff, and thereafter the son sold out that land again to defendant number 1, Lordship. When father already handed over, how he is entitled, he has any right over that plot of land, Lordship. That substantial question of law is not a substantial question of law, Lordship. It's just a question that whether sale deed can be cancelled when the plaintiff was declared as a tenant. I was declared as a tenant by both the courts, Lordship, and their sale
No,
deed
I
was.
cannot argue on that point because after hearing you, this substantial question of law was raised.
No, Lordship.
Now
were
you
not,
are not entitled to argue on that.
we were not
You
present
may,
at that
you
time,
may entitled to argue at the time of final hearing, not at this,
Lordship.
because it is not your case that you have not been heard for framing the substantive.
On Lordship, that day we were not present, Lordship, on 22/2017.
Uh, oh, learned for the Qadir learned appellant making it court to the decision of the owner group, the decision of the learned trial court as well as first appellate court submits that the appellant had determined four witnesses and none of the court below in their judgments had in the dispute judgment had discussed the evidence of DW1, DW3, and DW4. And as such, the findings were recorded by the learned trial court as well as first appellate court upper court, and on such ground, a substantial question of law is required to be met. And therefore, this is frame additional substantial question of hence today the respondent of opposed the submission of Mr. Kadir and appellant. However, take to the party and also going to the decision of the learned trial court as well as first appellate court. First appellate court, this court is this court satisfied to both sides. In none of the judgments, trial court as well as first appellate court has discussed the evidence deduced by DW1, DW3, and according court time frame another additional substantial that whether the judgment of the learned trial court and first appellate court suffers perversity on account of non-consideration of the evidence DW1, DW, DW3, and DW4 citing the and the point at the time point 47 is the matter to final hearing on
In the month of September, Lordship, it will publish. Maybe taken on some other date, Lordship. I have prepared that one, so I could not prepare this one. But
but instead of by learned advocates of both the parties, that's the
Let me pray date.
after
Can it be earlier 2017 matter, long pending matter? But
the problem that it takes up both vacation then your better not be last part.
last part of but
some other day, Lordship, on 25th September, that was fixed, or maybe the earlier one.
the
Lordship.
23rd September. 18th September. Well, high level, mass of.
Obliged.
May it please your lordship, there is some personal difficulty of my senior, your lordship. Lordship, I pray that we may be accommodated.
Lordship, it is the third time, your lordship, the appellant has been long pending matters, your lordship. Regularly a short time, your lordship. Susan, this the date.
Deeply obliged.
Obliged, your lordship.
It's not painful, it's true. It's just taste to go. It's just taste to go. Painful in the same. Number two to reply with it. Number two to go. Selecting for the product. It is a no. Oh. Lordship, on earlier occasion, I want to take the instruction regarding suit pending between the parties. I have received a copy of the plea note. Earlier, the next suit filed between the parties. And this present appeal is admitted on 16/12/2019.
What is the present status of that item?
Look, at present status, I am not in a position to understand, but I have informed the council. Another council was appearing, Rajit Bhaiya was appearing in the case. Today also, I have made an inquiry regarding the stage of the case. But I'm surprised to, I should not say all these things, Rajit. According to my information, the vendor of the present respondent, they have not appeared in the trial court in the present suit. And in the present suit, I have verified the Ukalatnama file in the present suit. That is also disputed, Lordship. The signature does not tally the Ukalatnama filed by the respondent number 2 and 3. Ukalatnama do not tally, but they have, without receipt of notice, they have filed Ukalatnama. So there is some. I should not say all these things, but someone has appeared. But signature in the Ukalatnama do not tally. With the documents which were filed along with the earlier. And both of us agree today it is not possible to miss the matter. Any date possible.
Before vacation, otherwise, concurrent findings.
In the month of September,
Lordship.
the secretary learned in the effect of both the parties. Provided that
May it please you. May it please your lordship. This is an appeal against the judgment and award dated 7/7/2018, passed in MSC case number 2308 of 2014, lordship. Lordships, we have filed this appeal only on certain limited grounds, lordship. What happened, lordships? The accident was occurred on 31/12/2013. And during our investigation, the investigator has inquired about the matter, and he has filed an application before the DTO Mon Nagaland, and on his verification, it came to our knowledge that the driving license was not as per their office record. Accordingly, we have we have issued an summon to the DTO Mon, but he was not appeared. Thereafter, on on 23/11/2017, the date was fixed for appearance of the DTO Mon, but on that day he did not appear, and accordingly we have filed an application before the learned tribunal, and the learned tribunal has rejected our petition, and the matter was fixed for argument. And another thing is that the learned tribunal, while awarding the claim of the claimant, has computed rupees 70,000 on the head of loss of love and affection of the minor children, which is not warranted in view of the decision of the Honorable Supreme Court in Pranay Shetty's judgment, Lordship. These are my
So when is judgment was pronounced?
judgment was pronounced on, Lordship, 7/7/2018, Lordship.
18, and when Pranay Shetty judgment was
That was in the year 2000. Fifteen, Lordship.
2017.
So, sorry, 17.
So the learned court would to have considered the of the Pranay Shetty.
Yes, Lordship.
That was not considered. So regarding this loss of dependency, the tribunal has fixed 4,80,000.
Yes,
Do
Lordship.
you have any doubt regarding?
4 lakh, that we have not doubt, Lordship.
But the stand you have taken that the license is
Yes, Lordship.
false,
Yes, Lordship.
but you failed to establish it.
But we have issued someone, but the DTO has not appeared.
But that does not mean that you have been able to establish it. Report is with you, but you have to prove the report
Yes,
by
Lord.
examining the person who had issued that report. But you have not able to.
We have issued someone, and he was not appeared. And on that day, as he was not appeared, we have filed a petition before the learned tribunal, and learned tribunal has rejected our prayer, Lord.
But you have not challenged that order.
That's true, Lord.
So if what we can do is only we can modify
Yes.
this this segment number 3, 75,000.
Yes, Lord.
And in respect of this segment number 2, that consortium 50,000. Any doubt regarding?
Regarding Lordship loss of consortium, that also we have challenged here. That is an excessive amount as per our.
What is provided in the pronotation? Any other point?
Only three, there are 3 points, Lordship.
3 point. Yes.
As regards the driving license being fake,
But the record was.
it's recorded
Yes,
received, madam.
Yes.
The one of the ground is that the driving license of the driver was fake. That is one of the ground, but that could not be proved. No evidence has been given. Neither it has been proved. Even if we take it to be true, there is a certificate from the DTO MON. If a lordship can see that in the records, it is there. In the written argument, they had given it, but it does not say that the driving license was fake. They say that we could not verify because from 2014 December onwards, the driving licenses were digitalized. So any paper driving license, if it was existing, we cannot check that. They went to for verification in the year 2018, madam. In the year 2018. The accident took place in December 2013. The driving licenses were digitalized after 1st of December 2014. So they went after 3 or 4 years. And by that time, they could not verify whether a driving license was there or not. It doesn't say that the driving license which was there was a fake. That is one part of the argument, madam. Ground case. And regarding consortium, my consortium chronicity said that 40,000 should be given. And thereafter Magnum came, my lord. Magnum says each of
Here, the tribunal has given 50,000.
50,000, only one. The wife is there and 3 children are there. I'm representing them, my lord. So Magnum says each of them should get 40,000. So it should not be 50,000. It should be 1,60,000, 40,000 each. And regarding, my lord, okay. Go to the pronoun. Magnum. And we had claimed that the victim, his salary was 8,000 rupees. He was working as a mason. It was not a salaried job. But the tribunal took into consideration an amount of rupees 3,000, approximately 3,000 rupees per month. On the basis of rupees 3,000 per month, the entire calculation was done. The calculation does not give the breakup, my lord. The entire breakup has not been given. It just gives 4,80,000. The calculation is not there.
Whether you have exhibited any document in respect of illegal.
We couldn't, my
No.
we couldn't. But it was not
Tribunal perhaps taken the notional line from the.
notional income. It says total demand. It comes around 5,000, my lord. In 2013, the minimum wages.
But you have not filed it appeal.
I have not filed an appeal, but
Yes, sir.
but even if you have not filed an appeal or a cross appeal, the lordship can consider whether a just compensation was given or not. Lordship already. Okay. There are several decisions, my lord. I'll place one or two. Diagram of diagram two. Diagram two. Like place Magnum, my lord. Paragraph 20. If I may please, paragraph 20, madam. MSCT as well as the High Court have not awarded any compensation with respect to the loss of consortium or loss of estate, which are other conventional head under which compensation is awarded in the event of death, as recognized by the Constitution Bench in Pranay Sethi. The Motor Vehicles Act is a beneficial and legislative welfare legislation. The court is duty bound and entitled to award just compensation, irrespective of whether any plea in that behalf was raised by the claimant. In excess of our power and paragraph 24, my lord.
For 21.
Paragraph 20 and then 24. Paragraph 20 is as regards, even if you have not claimed or filed a cross appeal, the lordship can grant a just compensation. Then 21 also, my lord, each and every one of the family members dependent.
Where it is provided?
Paragraph 21, my lord.
Point.
21 starts the starting paragraph in internal page 136. A constitution bench in Pranay Sethi dealt with the various heads under which compensation is to be awarded in a death case. One of these heads is the loss of consortium. In legal parlance, consortium is a component so and so, encompasses spousal consortium, parental, and filial consortium. The right to consortium,
Where it is provided that each of the
my lord,
family member will attend.
in the calculation at paragraph 25, my lord, serial number 10. Serial number 10. Loss. There were two.
That is in the calculation, but where it is provided?
It is there. I'll just provide it. Yeah, you know, people like that. Fusion of the report. Filial child of parental of
My lord, 21.1 and 21.2. Spouse will get separately, then parental consortium is granted to the child.
The
And-
present is how many? Second and third year?
4, my lord, wife and 3 children.
Four.
So each 40,000, it will be 1,60,000. My lord,
Lordship, regarding driving license, Lordship, there is a notification by the government of Nagaland. Here it is written that driving license is issued on smart card through the National Software Sarti from 30th October 2009 in the state. All licenses issued on Sarti can be viewed, verified through the national portal www.so. Issue of driving license on booklet has been discontinued in the state after smart card has been introduced. Does any license purported to have been issued by any authority in Nagaland on booklet from after 30th October 2009 is not genuine? Here in this case, Lordship, the accident was occurred on 2013, Lordship. So the government of Nagaland has issued the smart card from 30th October.
This is right, but whether you have exhibited that document,
That we have not exhibited, but
then
we have issued someone, but they have not appeared, and thereafter we have filed a petition, and that is also rejected.
okay.
and the verification was even after he didn't come.
Or the doctor, learned counsel for the appellant, and the Prasad for the argument.